records.
Yeah. From Isaac.
Yes. Morning, Rick. All right.
What you do, or synergy. That's why it does. That's what.
Oh. Oh, wow.
Right?
No needed, metro.
Like, she's so much nicer. So that's. So that's where there's getting.
Oh, yeah.
Yeah, it's so-
You tell them that people 4 months.
And then just.
Oh.
Good morning, everybody.
Good morning.
Where are you all planning on standing? Or closing?
How are you?
Are-
Say another one.
Where are you all
Everybody was
planning?
busy.
Like right here. Okay. Yeah. Are you all also planning on standing like about right here for closings or
Some-
just kind of?
Yeah, well, wherever works for the board, yeah, that probably right in there. This little gap here, probably
Gotcha.
where I'll spend most of my time.
Perfect. Okay.
How we doing on juries?
Court come to order, rise. Everybody, please. Stand. Off the record, I hear there have been some filings overnight or this morning. Is that right, Mr. Elford?
Yes, sir. I wanted to make people aware that we did file a notice of our past medical expenses claim.
Okay.
So we had previously abandoned future medical expenses. Last night, we filed a motion for bail and 165 of the past medical.
I see you also have some jury charge tenders.
That's correct. Mine's part to speak about that.
Your Honor, just off the record, we'd like to walk you through the jury charge tenders. I know we have discussion of those three yellow items that you had highlighted
Sure.
yesterday. And if Your Honor would permit me, I won't take long and I'm not going to re-argue anything, but we noticed that there was an issue of question 1 and 2 in terms of it's submitting the actual control, and we have some language that would correct that problem. And then I have 3 variations. I would like to talk you through at least one of them in an attempt to convince you to give that variation instead of the question 1 as posed, but I can do that on the record and explain our reasoning why.
Okay. Is there anything we need to talk about off the record before we deal with those issues?
Not that I'm aware of, Your Honor.
All right, Abby, let me know when you're ready, please.
Yes, sir.
All right, would the parties please state their appearances for today's record?
Yes, Byron Alfred, along with co-counsel Johnny Alfred, Rachel Beard, and George Gore of the Alfred firm in behalf of plaintiff Justin Francis.
Your Honor, Parth AG, Russell Post, and Elizabeth Butler from the firm of Beck Redden on behalf of plaintiff as well.
Kevin Yankowski, Peter Tibbs, Norton Rose Fulbright, on behalf of the defendant Sasol Chemicals USA, along with co-counsel Brian Cathy.
All right, thank you, counsel. All right, you all have seen the proposed jury charge from the court, I presume, is that correct? It went out yesterday around 4:30?
Yes, Your Honor.
Yes, Your Honor.
Yes, Sean.
All right, I understand the plaintiffs had filed some jury charge tenders and would like to talk specifically about the control instructions.
Yes, Your Honor.
Would
Thank
you-
you, Your Honor.
Would you walk me through those?
Yes, Your Honor. I'd like to begin with question number 1. And Your Honor, in reviewing the chart that was circulated by Your Honor last evening, we noticed that question 1 and 2 only submits an actual control theory, and the court had denied the directed verdict of defendants on the contractual control theory. And so we have some language we can insert in question 1 and 2 so that it submits both the actual control theory and the contractual control theory, Your Honor. And currently, question number 1 reads, did Sasol Chemicals exercise actual control over, and then it goes on to describe the manner of the work. And what we would propose is, did Sasol Chemicals exercise actual control or retain contractual control over, and then describing the manner of the work.
Do y'all have a response to
And
that?
Judge, without waiving our motion for directed verdict, we understand the court's ruling. I think we're fine with that modification. If the court is not inclined to revisit its directed verdict on the issue of contractual control.
I am not inclined to revisit the directed verdict. So is that question number 1, variation 1? Is that what you're referring to? Which variation are you talking about?
So it's not any of their variations. They modify other provisions in their 3 variations, Your Honor.
Yes, Your Honor. So he's absolutely right. I'll talk you through variation 1 in a minute.
Okay,
The modification is just to insert the words or retain contractual control. So did Sasol Chemicals exercise actual control or retain contractual control? And that would be for question number 1. And similarly, Your Honor, in question number 2, it would read, did the negligence, if any, of Sasol Chemicals in exercising the actual control or retaining the contractual control you found in answer to question number 1 approximately caused the injury in question?
all right, Mr. Kathy, you're okay with those provisions?
I think a simpler modification to question 2 would just be to delete actual and just leave it as control.
Your Honor, that's fine with us.
Okay, so delete actual, leave control and take out everything, or retaining the contractual control.
Right, so it would read, did the negligence, if any, of Sasol Chemicals in, Your Honor, I think it should be in exercising or retaining control.
Control.
Would that be acceptable? In exercising or retaining control, you found and answered.
Yes, I think that's fine, Your Honor.
Your Honor, I'll now go back to question number 1 and walk you through my tenders. And Your Honor, if I may approach, I'd like to give the tenders to you so that you may sign them.
Sure.
Your Honor,
This is the same as what was filed, is that right?
yes, Your Honor. Your Honor, I'm not going to walk you through all 3 of them because I understand Your Honor's rulings from yesterday and you rejected our formulation yesterday. But over the evening, our team really thought about what would use the word remote controlled locomotives as Your Honor had wanted, but also capture what we think would be a better question for the jury. We do think that the current question could allow the jury to answer yes, and that we could defend such an answer based on the evidence. But we think this encapsulates a little bit better what our theory of the case is. And the question would read, did Sasol Chemicals exercise actual control or retain contractual control over the selection of remote controlled locomotives as opposed to conventional locomotives, thereby controlling the manner in which Justin Francis worked, other than having the right to order the work to start or stop or inspect progress or receive reports? And Your Honor, I'd like to say just 3 things about why we think this is a better question for the jury. First, it is the court's charge, but the Texas Supreme Court has repeatedly said that the plaintiff is the master of the complaint, which means the plaintiff gets to try the case it wants.
The defendant might have very good reasons why we don't have sufficient evidence, but we should be allowed to ask the jury the question we want of the theory of the case. Second, Your Honor, I went back and read our fourth amended petition this morning, and our fourth amended petition really focuses on this theory about requiring remote controlled locomotives as opposed to the way the question is worded right now. And so I think it would conform with our petition. And third, Your Honor, I would just say that this question allows both sides to have a fair fight about the evidence and won't limit anyone in closing arguments. I've tried to make it as neutral as possible.
The guiding principle, obviously, is the court's required to actually submit the charge consistent with the law. There's a number of issues, legal issues with this. I mean, to start, the pattern specifically says you need to define the particular activity that is at issue. The activity that they're alleging is the operation of the train. The court has properly defined it. This variation focuses the jury on an issue that happened in 2015. It's not the injury producing activity. The selection of the provision requiring the use of remote controlled locomotives comes from 2015. That's not the injury causing activity. It improperly defines the issue, and it also creates strict liability. All the jury has to find is that a remote control locomotive is involved in the collision, and then regardless of the circumstances, that's legally operative control that will support a liability finding. There's absolutely nothing in the law that supports that. We provided the court with a number of cases that specifically reject this proposition in our proposed charge, and we discussed them at length yesterday. I'd cite the court to the Tiras versus El Paso Sand Productions case out of El Paso, where the court specifically said in that case, if the hauler was required to operate a specific type of trailer, and they said, in that case, it's not the requirement for the use of equipment. It is how you operated the equipment on the roadway in question. That's the relevant type of control. And so the court's properly defined the relevant inquiry in this case. And, you know, to the extent the court even entertains this, there would have to be a host of additional modifications and additional instructions because it's not complying with the pattern to narrowly focus the jury on the relevant issue.
Your Honor, if I may respond briefly.
Sure.
I read the Tiras case before the charge conference yesterday. It's very different. That's a case that involves a trucker. The employer had no control over the trucker. And basically, that was the issue in that case. Here, the control we have alleged is not the manner in which Mr. Francis was pressing the buttons on the day on the remote control. It's the fact that he was required to use the remote control locomotive in the first place. That's the theory of control. Second, there are different kinds of control that can give you a liability theory. For example, if you direct an independent contractor to drive in a certain manner at a certain time, then your duty is commensurate with that control. But Haute-Salonise recognized that for different kinds of control, for example, imposing safety requirements, if they increase rather than decrease the danger, then you have a different kind of duty. And so we're just asking the court to enforce or allow the jury to enforce the duty that is commensurate with the control here. And the control here is really not Sasol Chemicals being right next to Mr. Francis on the day of and overseeing what button he was pushing. It's requiring the use of the remote control locomotive in the first place.
All right, I am going to modify question number 1 to read, did Sasol Chemicals exercise actual control or retain contractual control over the manner in which Justin Francis operated the remote control locomotive on the occasion in question, other than the right to order the work to start or stop or to inspect progress or receive reports? I am going to refuse the other variations.
And one minor typo, I think there needs to be a question mark instead of a period, but otherwise, I think that is fine.
And Your Honor, just for purpose of clarity, that means you'll be refusing variation 1, 2, and 3 in our tenders.
Correct, and I have signed those and I will make sure they get part of the record.
Thank you, Your Honor. Your Honor, we can next discuss the 3 yellow highlighted items, but before we do so, we noticed a small issue, which I don't think will be controversial in the beginning instructions. We noticed that the PJC instruction about direct versus circumstantial evidence had been left out of the opening instructions, and I wanted to see if the court was willing to give that instruction or if I should tender the instruction. The instruction would read, A fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from the other facts proved.
Any objection to that?
It's up to your honor. We don't have an objection. If the court wants to include it, I don't think it's necessary, but we're not gonna lodge an objection to it, your honor.
Okay, if that was in your proposed charge, I just missed it when I was putting this
Your
together.
Honor, I have it on a separate sheet of paper here.
If you approach, I'll take that. Thank you.
Yeah, provided it's straight PJC, I assume it is. Okay.
Your Honor, next I'd like to discuss the 3 sentences highlighted in yellow and kind of explain our reasoning for why those instructions should be refused. And I'll begin with the first instruction that they have requested, which is a contractual right of control requires evidence of a contractual agreement that explicitly assigns the premises owner a right to control. And they cite the Texas Supreme Court Dow Chemicals versus Bright case from 2002. And I would point out a few things to the court for why it should refuse this instruction. First, this was a premises liability case, not a negligent activity case. But more importantly, this case occurred in the context of a motion for summary judgment. The holding of the Texas Supreme Court was that there was no fact issue as to contractual control. The plaintiff couldn't point to any contractual provision showing any kind of control. But of course, Your Honor, in this case, the court has denied directed verdict, and we can point to different kinds of provisions that we believe the jury should be able to assess in determining contractual control. And so the idea that you need an explicit contractual provision does not square with the jury's job in this case, which is to read the entire contract and harmonize the contract. I'll also point out, Your Honor, that the provision or the language about explicitly assigning the premises owner a right to control, that wasn't a basis of the Texas Supreme Court's holding. The basis of the Texas Supreme Court's holding was there's no fact issue. Plaintiff cannot point to any contractual provision. And the case that the Dow Chemicals case cites, the Coach case from the Texas Supreme Court, does not use that explicit language. And therefore, we would argue that this statement or instruction would be misleading to the jury and would not capture the kind of fight we're having about contractual control in this case.
Kathy, in response?
These are non-pattern instructions. I think the court has some discretion and leeway in terms of how much additional instruction the court is going to give. You know, of the 3, I think the last one is probably the most relevant, and that is, you know, instructing the jury on the issue of the condition versus actual proximate cause. And like I said, Your Honor, we recognize the court has some discretion in which, if any, of the instructions to give. And so that would be my response. I think all of them are legally correct. And so I'm not certainly conceding that Mr. Parth is, you know, has validly distinguished any of the cases. But, you know, we understand the court's rulings, and we understand it's 9:10 in the morning, and we're gonna close at 9:30, so.
Your Honor.
Oh, you're not going to close at 9:30?
If the jurors are here, Your Honor.
Your Honor, I'll just briefly respond that all 3 instructions, we have detailed reasons about why they're not legally relevant to this case, but all 3 are surplusage. Moreover, they're a comment on the weight of the evidence in the defense's favor. And we would rather have a PJC submission that's exactly like the PJC without any of these surplusage instructions, which in our view are also legally irrelevant to this case.
All right, I'm going to take out the instructions on question 1.
Your Honor, I'd like to tender instruction just for purpose of preservation. It was in our discussion yesterday for question 1. It says, control may be established through evidence that Sasol Chemicals required equipment to be used that was unsuitable for its intended use. If I may approach, I would like to tender it to you.
Thank you.
Your Honor, moving on to question number 2. Would first like to object to the conditioning language at the top of the page that says, if you answered yes to question number 1, then answer the following question. Otherwise, do not answer the following question. And the reason, Your Honor, is, as Your Honor knows, yesterday we moved for directed verdict on contractual control affirmatively because we believe we can establish it conclusively. And we believe that should the jury end up deciding no to question number 1, there's still a viable basis for the court to issue a judgment in plaintiff's favor because contractual control would be conclusively established. And so we would require the jury to answer question number 2 to know whether that control was exercised negligently or not.
Your response to the conditioning part of question 2?
It goes to the, I generally don't like predicate instructions, including on the damages. I think they inform the jury of the effect of the answer, but the Supreme Court has said that predicates are helpful in that if the jury's not required to deliberate, there's no point to keep them back there and potentially deadlock on issues that are immaterial. And so, similar to how the damages questions are predicated, I think a predicate for the negligence submissions is appropriate. Yeah, you shouldn't carve out negligence, but leave damages because the plaintiffs like that. I mean, I think logical consistency requires either all the predicates be removed or all of them be inserted.
What are your thoughts on that?
Your Honor, all I would respond with is we're respectful of your discretion in this case, and we've made our objection to preserve our issue. I would just say that we do run the risk of retrial if we're right about our contractual.
I can tell that just from the number of appellate lawyers in this court.
Yes, Your Honor, but we would just ask for a ruling on our objection, Your Honor.
That objection is overruled. Any other issues on question 2?
No, Your Honor, with the understanding that we'll be fixing that language about exercising or retaining control.
So my understanding is question 2 will be modified to read, did the negligence, if any, of Sasol Chemicals in exercising or retaining control you found in answer to question number 1 proximately cause the injury in question?
Yes,
Have
sir.
a "the" in there, the control you found. Thank you.
Okay. Got it. All right, any issues with question 3?
Not from the plaintiff, Your Honor.
So Judge, just to be clear, I do have some tenders that I'll propose at the end that we've discussed repeatedly, but just for the record, we'll require them to be signed. The only issue with 1, 2, so no issues with 3, I guess, is to short circuit that, but I do have kind of a comment on 4.
Okay.
Your Honor, we can move to 4. And Your Honor, I think I may anticipate Mr. Cathy's comment, which is we would want the conditioning instruction. We do think the conditioning is appropriate, but I think it needs to read, if you answered yes to question number 2 and question number 3, as to any party named below, comma, then answer the following question as to that party, or something similar to that, so that the jury doesn't get confused.
Yeah, as to more than one of those named below.
But that would be fine with us, Your Honor.
Oh, I see.
All right, any other issues with question 4?
No, Your Honor.
All right, how about question 5?
Your Honor, on question 5, there are 3 typos, which I think will not be controversial. On number 1 and 2, Mr. Francis's name should be spelled Francis. And then on the question itself, it should be what sum of money if paid now in cash?
Yeah, that's.
I was trying to trick you all.
That's really, yeah, that's really good.
And then, Your Honor,
And a question mark too, I think.
a question mark at the end of that question. And then, Your Honor, on physical impairment, I believe it should be Physical impairment means a loss or diminution of the injured party's ability.
Right, any other issues with question 5?
And Your Honor, finally, since we have abandoned the claim for past medical care, we would ask that A, which is about that damages line, be taken out of the jury charge. Right. And Your Honor, we would humbly ask that when you take out A, that the pagination is such that, you don't have the description of the category of damages on one page and the blank on the next page.
So you want the elements starting on page 9 effectively? Is
Oh.
that right?
Your Honor, yes, Your Honor. And then the last item on this page from our side, well, 2 items from our side is first, we would object to the mitigation instruction that's been given that says do not include any amount for any condition resulting from the failure, if any, of Justin Francis to have acted as a person of ordinary prudence would have done under the same or similar circumstances in caring for and treating his injuries, if any, that resulted from the occurrence in question. And our reasoning, which I won't repeat at length, but which we discussed, is we don't think there's a failure to mitigate case. That instruction is usually given when you don't consult your doctor, and that's not the case here.
Any response to that?
Yes, Your Honor. The issue is a failure to mitigate that doesn't only apply to medical expenses, it applies to all types of damages. There is evidence that the plaintiff only applied for one job, yet is seeking substantial sums in lost wages, both past and future. So clearly there's an issue for the jury there. And the way the question is formulated, it says any lost damages associated with the injury. And so if the jury's not affirmatively told that there's an obligation to mitigate by actually going out and getting a job to the extent possible, then the jury's going to be left to infer that they have to award sums even though they could have been offset.
The objection on the failure to mitigate is overruled. I'm going to leave that in.
Your Honor, we would also request, if that instruction is going to be given, an instruction about loss of earning capacity, which I'll tender to the court in a second. It would read, for loss of earning capacity, it is not a prerequisite to recovery that the injured party be employed at the time of injury or prove his ability to stay employed over the period of years in which loss of earning capacity is claimed.
Where does that come from?
Your Honor, that comes from the City of Houston case. I can tender it to you, Your Honor, so you can look through.
Has Sassel seen that proposed instruction for number 5? And do you have any
I
thoughts?
saw it about 20 minutes ago, Your Honor. I mean, it jumps out to me as one, not supported by the evidence. That's not the contention. The contention is the plaintiff undisputedly had the ability to obtain some work and yet hasn't sought that work. So that is the legal operative question. This addresses prerequisites to employment, which aren't really even at issue. I don't really understand the instruction. I've read it several times, but it doesn't even seem to be applicable in this scenario.
And to the point of it being undisputed that he was able to work and employable at the time period that he was unemployed.
I will correct that. Yeah, I would just say, I meant to say that there's a factual dispute for the jury. And so I don't want to say it's conclusively established or anything like that. I appreciate that.
All right.
I'm going to refuse plaintiff's requested instruction for question number 5.
Yes, Your Honor.
I've signed that.
Your Honor, finally, given your direct verdict, the gross negligence questions that we had in our proposed charge are not in the charge. I'd like to just tender them to you so that you can refuse them, and there's no contention that we've waived any gross negligence.
Sure, come on up.
Thank you.
Yeah.
Similarly, Judge, while you're signing those, I will tender, I think it's clear from the record, the instructions that were discussed at length yesterday from the things that were filed, but I will approach with tenders instructing the jury to disregard contractual control consistent with our directed verdict, and then defining the relevant types of control. And so I'll approach with those. And it's consistent with those, Your Honor, we just review the objection, or really the motion for directed verdict as to the submission of contractual control and the commingling of the contractual control with the actual exercise of control, which, you know, leaves at least two possibilities open for a jury verdict and not knowing which one it is. And so that's why we're tendering those appropriate instructions. And that objection would apply to the submission in question one, and then would bleed over into the negligence question and the abortion question.
Your Honor, all we would say is that's inconsistent with the proposal we talked about changing the language of actual and or contractual control in questions 1 and 2. And if they're going to make a Castile objection, then we should be able to get separate findings from the jury as to actual control and contractual control.
In response to that.
Your Honor, I think we've settled on a form. Charge conference is concluded that the court has set the form of the charge. The issue is really the directed verdict. We've handled that. The court has not shown any inclination to revisit that, and just simply restating what's already been discussed for 4 hours yesterday and again this morning.
Your Honor, the only discussion of Castile yesterday did not have to do with actual or contractual control. It had to do with the context of whether we combine mental anguish or physical pain. That was the discussion. So there was no notice to us that there would be a Castile objection today, where if we combine actual or contractual question 1 and 2, that they're going to argue either after the verdict or on appeal that we should have gotten separate questions. And if they think that's our burden, then we would ask the court for an opportunity to give you questions to meet that burden. But they shouldn't be able to get that objection overruled and slip this issue into the case when there was no discussion of that in this context yesterday.
Great. Is there anything else related to the charge at this moment?
Nothing from the defense, Your Honor.
No, Your Honor.
All right, give me a few minutes to work on some revisions. I'll get you a copy to look over, and then we will make copies for the jury.
All rise.
You guys.
I'm not forgetting it, but.
Well, I'll throw something.
Right. Can we get a couple of quick candidates?
It was literally verbatim, but I'll give you the exact. They're verbatim from the things we discussed yesterday, so it's that one. Not now.
And there are questions about contraction, actual control?
No. That's it. I mean, it was literally all taken directly from what we discussed.
Okay.
So order one, yeah, do an independent cause. Then 4 or 3 definitions of control.
All right,
Yeah, thank you. No worries. And then I'll see you on to this one.
Oh, yeah.
and you didn't tender any questions about control?
No, there's not like a separate question.
Okay, got it. No questions were entered.
Yeah. Yeah.
Ryan, are you doing football this afternoon as well? Or is it 10:30?
Yeah, it's, Landon is covering it with Carlos from college.
Okay. Got it.
So is Nick or somebody from?
Nick is there. Well, I hope Nick's doing it, because I'm sure not Nick.
There's another jury charge conference.
It's one that, Brian and Nick and I, were in trial on about 6 months ago. It's a first step.
Oh. Yeah, Carlos tried another case against him, maybe like a month or two after ours, or maybe it was even more recent.
Against Kevin Stewart?
Yeah.
Oh, really?
Yeah, in New Mexico federal.
Okay.
And, yeah. Oh, those are nice.
How are you, Russell? Good to meet you.
They're nice guys.
Yeah, they are nice guys. They are nice guys. And I really enjoyed working with Carlos. I knew my reputation, but I had never actually been in court with him in this case.
Yeah. Yeah, he jokes the only thing between him and San Antonio are scorpions and I think that's right in terms of the defense side. So
Yeah.
he's got a lot of work.
Because I got this. Good.
Yeah.
Yeah.
Want to keep it all heads up, council. After closing arguments are done, the judge is gonna ask if y'all have gone through each of these exhibits, so just wanted to let y'all know.
Okay, my understanding is they have or are currently doing that. I would,
Okay.
I'll double check that.
Beautiful, thank you.
Yeah. Actually.
And
Motion.
Y'all have worked well with one another. We're gonna finish this strong.
Thank you, Judge.
we're gonna try.
Did you all get the electronic copy?
I'll be asking the wrong person.
I sent it to the same people I did last evening, so if you needed to go elsewhere, just forward it.
I received it. Thank you, Judge.
And Judge, I assume for this Coronado break, if for no other reason, we'll take a quick break in between closings if he's gonna go an hour.
My plan is to let Mr. Elford do the first hour of his closing. We'll probably take a break. You can then do yours.
I'll need a moment just to set up. I won't be very long.
Okay, we're gonna take a break after Mr. Elford initially. If you really stick around the hour mark, we'll probably go right into your rebuttal once Mr. Yankowski finishes up. But if you take your hour and a half, we'll probably take another break before we get to rebuttal.
That's fair enough. Like I said, I can't time it to the second, like most
Understood.
things, but I don't expect to need a full hour and a half.
Okay. Do you want a warning, either of you, a time warning, or will you be monitoring that?
Yes, Judge. I will be monitoring the time, but a 10-minute warning would be.
10 minutes, okay.
Thank you, Judge.
And
On both your rebuttal and your,
Yes, Judge.
okay,
I should be okay, Judge.
okay. Right. Tried to. Just test the real stuff. I didn't have it all. Just to make sure.
Testing.
Okay, thank you.
Sir.
Everyone's here. I told you. Oh, I just assumed. It's 10 o'clock. I assumed everybody is.
Your Honor, we are making a couple of modifications to my presentation based on this new charge.
Okay,
In 10 minutes. Is that okay?
that's fine. We're working on copies and things for the
I
jurors.
haven't seen, you got any new demonstratives in it or is it all?
Screenshots of the charge.
That's fine.
So,
That's fine. All I've got is evidence and then, maybe some, pieces of the testimony. No new demonstratives. Okay.
Abby, I don't think we have enough minutes.
That's mine. I did that.
These are gonna be long closings.
If I'm boring you, you can suck on. If I start hearing crunching,
Crunching and whistling.
that'll be the sign to shut up and sit down.
Oh, you really did give out a lot of minutes. Did you give out a lot of minutes? Yes. Just be careful with the top of that. It's loose. Well, you already turned the microphones off. Good job. You already turned the microphones off.
Definitely.
Did you turn the microphone on?
I did.
Aye.
Oh, I did.
Appreciate it, Ann.
Oh, thank you so very much. I don't, I'm assuming so, yeah. I've really missed something if we.
That number is 269.15. I don't think, well, that's what I heard there. But I'll find it. Okay, I can do this for all space. This closing change. Got you. Do you want me to be the first option, this or go? Courtney? Okay, I'll ask Courtney when we're doing the closing. I'll just walk over there and talk. Okay. Yeah.
Welcome to my.
Excuse me, council, are both of y'all using, slide presentations for closings?
I'm gonna throw up some exhibits and some testimony, but I don't have a PowerPoint
Okay,
per se.
okay.
Just got,
It's gonna have a keynote presentation, so.
Is that gonna be displayed? If you wouldn't mind, could you email that to me? Or is it?
No, I can get it, I
Okay.
can tell them right now.
Okay, thank you.
Judge, we've not seen this keynote, but I'll take Mr. Alford's word that there's nothing new, no new demonstratives or anything in it.
Okay,
So we don't need to delay any further.
okay.
Yeah. I'm sorry. It slipped his mind. Yeah, he didn't tell me, he didn't tell you he found the video.
Mr. Elford, how are we doing?
Ready? Man's coming in now. Um.
Mr. Elford, are we far enough along we can start to line up the jury?
All rise for the jury.
Good morning, everybody. Please have a seat. Welcome back. It feels like I haven't seen you in a few days, but it's good to see you all. We have made it to the end of this trial. In your chairs, you will have a copy of the charge of the court. I am obligated by law to read that to you, so you are certainly welcome to follow along as I do that. Once I have read the charge to you, both parties will have an opportunity to present their closing arguments. Members of the jury, after the closing argument, you will go to the jury room to decide the case. Answer the questions that are attached and reach a verdict. You may discuss the case with other jurors only when you are all together in the jury room. Remember my previous instructions. Do not discuss the case with anyone else, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in dictionaries or on the internet. Do not post information about the case on the internet. Do not share any special knowledge or experiences with the other jurors. Do not use your phone or any other electronic device during your deliberations for any reason. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during deliberations, but do not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. You must leave your notes with the bailiff when you are not deliberating. The bailiff will give your notes to me promptly after collecting them from you. I will make sure your notes are kept in a safe, secure location and not disclosed to anyone. After you complete your deliberations, the bailiff will collect your notes. When you are released from jury duty, the bailiff will promptly destroy your notes so that nobody can read what you wrote. Here are the instructions for answering the questions. Number 1, do not let bias, prejudice, or sympathy play any part in your decision. Number 2, base your answers only on the evidence admitted in court and on the law that is in these instructions and questions. Do not consider or discuss any evidence that was not admitted in the courtroom. Number 3, you are to make up your own minds about the facts. You are the sole judges of the credibility of the witnesses and the weight to give their testimony. But on matters of law, you must follow all of my instructions. Number 4, if my instructions use a word in a way that is different from its ordinary meaning, use the meaning I give you, which will be a proper legal definition. Number 5, all the questions and answers are important. No one should say that any question or answer is not important. Number 6, answer yes or no to all questions unless you are told otherwise. A yes answer must be based on a preponderance of the evidence. Whenever a question requires an answer other than yes or no, your answer must be based on a preponderance of the evidence. The term preponderance of the evidence means the greater weight of credible evidence presented in this case. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or by the number of documents admitted in evidence. For a fact to be proved by preponderance of the evidence, you must find that the fact is more likely true than not true. Number 7, a fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. Number 8, do not decide who you think should win before you answer the questions and then just answer the questions to match your decision. Answer each question carefully without considering who will win. Do not discuss or consider the effect your answers will have. Number 9, do not answer questions by drawing straws or by any method of chance. Number 10, some questions might ask you for a dollar amount. Do not agree in advance to decide on a dollar amount by adding up each juror's amount and then figuring the average. Number 11, do not trade your answers. For example, do not say, I will answer this question your way if you answer another question my way. Number 12, the answers to the questions must be based on the decision of at least 10 of the 12 jurors. The same 10 jurors must agree on every answer. Do not agree to be bound by a vote of anything less than 10 jurors, even if it would be a majority. As I have said before, if you do not follow these instructions, you will be guilty of juror misconduct, and I might have to order a new trial and start this process over again. This would waste your time and the party's money and would require the taxpayers of this county to pay for another trial. If a juror breaks any of these rules, tell that person to stop and report it to me immediately. Definitions. Sasol Chemicals means Sasol Chemicals USA LLC. Savage Transportation means Savage Transportation Management Inc. Questions. Question number 1. Did Sasol Chemicals exercise actual control or retain contractual control over the manner in which Justin Francis operated the remote control locomotive on the occasion in question, other than the right to order the work to start or stop or to inspect progress or receive reports? Answer yes or no. If you answered yes to question number 1, then answer the following question. Otherwise, do not answer the following question. Question number 2. Did the negligence, if any, of Sasol Chemicals in exercising or retaining the control you found in answer to question number 1 proximately cause the injury in question? Negligence means failure to use ordinary care. That is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Proximate cause means a cause that was a substantial factor in bringing about an injury and without which cause such injury would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the injury or some similar injury might reasonably result therefrom. There may be more than one proximate cause of an injury. Answer yes or no. Question number 3. Did the negligence, if any, of those named below proximately cause the injury in question to plaintiff Justin Francis? Negligence means failure to use ordinary care, that is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Proximate cause means a cause that was a substantial factor in bringing about an injury and without which such injury would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the injury or some similar injury might reasonably result therefrom. There may be more than one proximate cause of an injury. Answer yes or no for each of the following. A, Justin Francis. B, Savage Transportation. If you answered yes to question number 2 and question number 3 as to more than one of those named below, then answer the following question. Otherwise, do not answer the following question. Assign percentages of responsibility only to those you found caused or contributed to cause the injury. The percentages you find must total 100%. The percentages must be expressed in whole numbers. The percentages of responsibility attributable to any one is not necessarily measured by the number of acts or omissions found. Question number 4. For each person you found caused or contributed to cause the injury, find the percentage of responsibility attributable to each. A, Justin Francis. B, Savage Transportation. C, Sasol Chemicals. The total must equal 100%. Answer question number 5 if you answered yes for Sasol Chemicals in response to question number 2 and answered no for plaintiff Justin Francis in response to question number 3, or 50% or less for Justin Francis in response to question number 4. Otherwise, do not answer question number 5. Question number 5. What sum of money, if paid now in cash, would fairly and reasonably compensate plaintiff Justin Francis for his injuries in question, if any? Consider the elements of damages listed below and none other. Consider each element separately. Do not award any sum of money on any element if you have otherwise under some other element awarded a sum of money for that same loss. That is, do not compensate twice for the same loss, if any. Do not include interest on any amount of damages you find. Pain and mental anguish means the conscious physical pain and emotional pain, torment, and suffering experienced by Justin Francis as a result of the injury in question. Loss of earning capacity means a diminished capacity to earn a living resulting from the injury sustained. Disfigurement is that which impairs or injures the beauty, symmetry, or appearance of a person or thing, that which renders unsightly, misshapen, or imperfect, or deforms in some manner. Physical impairment means a loss or diminution of the injured party's ability to engage in tasks or activities for one's own benefit or enjoyment. In assessing damages for physical impairment, you may consider the loss of enjoyment of life. The effect of the physical impairment must be substantial and extend beyond any pain, suffering, mental anguish, lost wages, or diminished earning capacity. Do not include any amount for any condition resulting from the failure, if any, of Justin Francis to have acted as a person of ordinary prudence would have done under the same or similar circumstances in caring for and treating his injuries, if any, that resulted from the occurrence in question. You are instructed that monetary recovery, if any, is not subject to federal income taxes. Do not increase or enhance damages as punishment. Answer separately in dollars and cents for damages, if any. Do not reduce the amounts, if any, in your answers because of the negligence, if any, of Justin Francis. Any recovery will be determined by the court when it applies the law to your answers at the time of judgment. Subpart A, physical pain and mental anguish sustained in the past. Subpart B, physical pain and mental anguish that in reasonable probability Justin Francis will sustain in the future. Subpart C, loss of earning capacity sustained in the past. Subpart D, loss of earning capacity that in reasonable probability Justin Francis will sustain in the future. Subpart E, disfigurement sustained in the past. Subpart F, disfigurement that in reasonable probability Justin Francis will sustain in the future. Subpart G, physical impairment sustained in the past. Subpart H, physical impairment that in reasonable probability Justin Francis will sustain in the future. Presiding juror, when you go into the jury room to answer the questions, the first thing you will need to do is choose a presiding juror. The presiding juror has these duties. Have the complete charge read aloud if it will be helpful to your deliberations. Preside over your deliberations, meaning manage the discussions and see that you follow these instructions. Give the written questions or comments to the bailiff who will give them to the judge. Write down the answers you agree on, get the signatures for the verdict certificate, and notify the bailiff that you have reached a verdict. Do you understand the duties of the presiding juror? If not, please tell me now. Instructions for signing the verdict certificate. You may answer the questions on a vote of 10 jurors. The same 10 jurors must agree on every answer in the charge. This means you may not have one group of 10 jurors agree on one answer and a different group of 10 jurors agree on another answer. If 10 jurors agree on every answer, those 10 jurors sign the verdict. If 11 jurors agree on every answer, those 11 jurors sign the verdict. If all 12 of you agree on every answer, you are unanimous and only the presiding juror signs the verdict. All jurors should deliberate on every question. You may end up with all 12 of you agreeing on some answers, while only 10 or 11 of you agree on other answers. But when you sign the verdict, only those 10 who agree on every answer will sign the verdict. Do you understand these instructions? If not, please tell me now. The last page of the charge of the court is the verdict certificate. If the verdict is unanimous, the presiding juror will check that top box and sign his or her name and print his or her name. If the verdict is not unanimous and is agreeable by 10 or 11 of you, the appropriate box should be checked, and the 10 or 11 of you that agree on the verdict should sign your names and print your names. The original charge of court will be signed by myself as the judge of the 215th District Court, and following closing arguments, Deputy Cavazos will place it in the jury room for you. With that, Mr. Elford, would you please present your closing argument on behalf of Mr. Francis?
Work.
Yes, sir.
Good morning. Ladies and gentlemen of the jury, I told you at the beginning of this case that this case is about safety rules. Rules that exist to protect people. People who work around trains, people who work around tank cars. Because trains and tank cars are powerful machines. Heavy, unforgiving, dangerous. And when the safety rules that control them are ignored, people get hurt. That is what happened here. But this case is also about something more. It is about the rules that are going to be in this community. Because your verdict tells everyone what is acceptable and what is not. This case is also about control. Because a contract is a contract. And control is control. Sassel made the contract. Sassel set the terms. Sassel set the conditions. Sassel required remote control locomotives. Sassel controlled how the work was done. And we showed you the documents. The city yard where this incident took place was leased from Kansas City Southern Railroad Company. We showed you Section 14.6 of the lease agreement, which said the following, that SASL shall be solely responsible for training and overseeing its employees, contractors, except KCS and KCS's contractors of any tier, and agents as to proper and safe work practices to follow when performing any work in connection with this lease. This is plaintiff's exhibit 200. And this provision is on page 36. You write that down. We showed you the contractor's SH&E handbook, which is a document that is given to SASL's contractors, such as Savage. Section 6.1.15 says the following. It is understood that all contractor safety representatives and safety programs are subordinate to SASL safety. And this is plaintiff's exhibit 156. And this provision is on page 19. You should write that down. Now we showed you the SASL site-specific rules. And this is the document that Justin told you that he was trained from. It tells specifically how Justin was expected to be operating the remote control locomotive while riding the lead car. And it says the following. Riding tank cars while operating the OCU, employee will stand on the platform outside the gauge of the rail, face the direction of the movement while maintaining 3 points of contact at all times. And eyes should be focused on the tracks and possible obstructions. This safety rule was the way that it was done. Justin followed this rule. If SASL had prohibited riding rail cars, Justin would have followed that rule. This is how he was trained. This safety rule, like all of the safety rules, was subordinate to SASL safety. This is plaintiff's exhibit 63. This provision is on page 24, and you should write that down. You also heard it from their own witnesses. We brought you SASL employee Anthony Borland. That was the SASL logistics supervisor at the time of this incident. And Borland told us that SASL logistics department provided the switch list. Now, which was the document that SASL provided to the city yard workers each day. All right, the switch list told the switchmen such as Justin what rail cars to move, where they needed to go. And Savage, through employees like Justin Francis, carried it out to a T, carried out those instructions given from SASL. You also heard that Borland was present at the city yard every week, while workers such as Justin were operating remote control locomotives while riding a lead car using 3 points of contact to get SASL's work done. And Borland never told any of the SASL employees, not Justin, not anybody, that what they were doing were violating any safety rules. You heard that. Next, we brought you Alette Riera. And Alette became the VP of Customer Fulfillment a few months after this incident. And she told you that SASL defined the scope of the work through that contract. And she told you that the contract required remote control switching. That's the contract between SASL and Savage. And she told you about the infamous letter exchange between Troy Savage, Mr. Savage, and herself. You saw that letter numerous times throughout the trial. Now, she wasn't working in logistics at the time of this incident, but she told you that she relied on the work of Mike Curligan to put together the letter that she wrote to Savage that ultimately Troy Savage responded to. And surely you remember Mike Curligan. Now, this is the letter. This is the letter that Troy Savage wrote back to Alette Riera. And I want to point to a couple of points within this letter that you saw throughout this trial, and a number of witnesses commented on it. But if you look at remember this was when Savage was complaining about Savage's safety policies and the way that they were operating their safety performance out at the sit yard. And of course, Troy Savage was responding back to Alette Riera saying, hey, these are all the good things that we're doing, we're improving. That's a 232% improvement of man hours. And the incidents are down over this time. But if you look at the second paragraph, in that first sentence, he said, we have been able to maintain safety performance above industry standards, despite the negative impact of SASL's requirement to use RCLs, remote control locomotives, at the facility. In the last sentence of this paragraph, Mr. Savage himself lets SASL know compounding these engineering challenges is SASL's required use of remote control locomotives, which is contrary to industry standards. And get this, is one of the primary causes of the only recordable injury we've had at the facility in the last 8 years. And we strongly believe that RCL should no longer be used at the facility, and request again that SASL transition to conventional locomotives as reasonably possible, as soon as reasonably possible. Now, this letter was compiled by a gentleman named Mike Hurligan. Surely you remember Mike Hurligan. We brought you Mike Hurligan over 2 days. And Mike Hurligan was the senior manager of rail and trucking logistics at the time of this incident. He worked out of the Houston office at the time of this incident. I think he said in the energy corridor. He also told you that SASL's contract required Savage to use remote control locomotives. He's in agreement with Alette Riera. He's in agreement with all of the SASL witnesses you heard from. He also told you that the contractor safety, he agreed that this contractor safety, based on what we saw in the contractor SH&E, was subordinate to SASL's rules. And he admitted that he pulled the incident data that was in the letter that Alette Riera sent to Troy Savage, which was ultimately responded to that we just looked at. But Mike Hurligan also told you that he worked at SASL for more than 40 years before he retired. He told you that he was working at the SASL Westlake plant where this incident occurred back in 1999 when a worker died while riding the railroad. He said that SASL's entire purpose for bringing remote control locomotives was to get workers off of rail cars. He told you that, sitting right there in the chair. He couldn't explain, in spite of all of that, why SASL did not impose a rule strictly prohibiting the practice of riding rail cars while operating remote control locomotives. Couldn't explain it. I asked him point blank. He couldn't explain it. He remembered it. Let's talk about Mike Hurligan's testimony. Hurligan told you that he had a hand in negotiating that contract between SASL and KCS. And I asked him about that provision 14.6, and this is what he said. I read it to him. I said, SASL should be solely responsible for training and overseeing its contractors as to proper and safe practices to follow when performing any work in connection with this lease. And I said, so that means, sir, SASL promised to make sure that everything was proper and safe at the sit yard, correct? And he said, yes. Remember that testimony, because they may get up here and try to convince you that this provision does not apply to the sit yard. And here, Mike Hurligan is telling you that they're wrong. Okay, remember that. You saw it happen right here in this courtroom. SASL controlled the switching operation in the sit yard, just like it promised KCS that it would. And Mike Hurligan told you that himself. Now let's talk about Richard Lee. Surely you remember Richard Lee. Richard Lee told you that he was the highest ranking person in the logistics department at the Sassel Westlake plant at the time of this incident. Richard Lee's most memorable moment was when he told us about the conversation that he had at a meeting with Savage Senior Management in January of 2021, about 6 weeks before this incident. It was a safety meeting. Richard Lee came into this courtroom and attempted to change his testimony that he had given at a prior deposition while he was under oath a couple months before we began this trial in Colorado. You remember this. I played the video of that previous sworn testimony in my opening statement. You heard him before he ever showed up to this courtroom. And he came before you and tried to change his testimony. Now, by the time he took the stand in our trial, Richard Lee told us someone from Savage told him during a side conversation or a side meeting that Savage wanted to switch from remote control locomotives to conventional locomotives. Y'all remember that? Richard Lee also told us that Savage based its request to switch to conventional locomotives from remote control locomotives on its desire to be more efficient as opposed to for safety reasons. He said that. And this is where I'll remind you of the instruction you just heard from our honorable judge, that you are the sole judges of a witness's credibility. You are. If you choose to discount or totally disregard a witness's testimony because you don't find it credible, you can. You can. Now, Richard Lee did, however, admit that after the so-called side conversation at the safety meeting, that he likely told Mike Curligan about Savage's request to go to conventional, and that it would have been Curligan's call to decide whether to approve the request, not his. Richard Lee, Mike Curligan, and Alette Riera all agreed that the reason that the request was denied was due to the contract between Sassel and Savage. And that contract required that Savage use remote control locomotives. Now, remember Sassel's rail expert, Dr. Mark Biggs. Remember him. He'd invoiced over $1,000 before he ever showed up to this court. He had read Richard Lee's previous testimony in preparation to offer his opinions in this case. And I stood right next to Mark Biggs with the testimony in hand, and I gave it to him. I gave him Richard Lee's sworn testimony a few months before this trial. And I asked him specifically, since he had reviewed this testimony, to show me where in the testimony that discussed the meeting that happened on January 28th of 2021, where Richard Lee mentioned anything about a side conversation or a side meeting. This was the last time he was under oath before he came to court. And Dr. Mark Viz, I gave him all the time he needed. I was standing right there. I looked at a few of them while he looked through the transcript, and he never found it. He never found it because it wasn't there. I also asked him to find anywhere where Richard Lee said anything about Savage basing its request to go from remote to conventional on efficiency. I gave him the binder. I stood next to him, gave him all the time he needed to look for it. And guess what? He never found it. And I know why he never found it, because it wasn't there. You are the sole judge of Richard Lee's credibility. You are. But what else did Dr. Viz tell us? All right, Dr. Viz told us that he worked for a company called X-Man. Dr. Viz told us that he had never operated a remote control locomotive, nor trained anyone in operating a remote control locomotive. Dr. Viz told us that Justin violated a safety rule by not using 4 points of contact, and that there was some kind of conflict between the rail operator's manual and the safety rules, the site specific that Justin was trained on. He's the only person that said that there was a conflict. But when I pressed him on this 4 points of contact business, and y'all remember this, he had to admit that the FRA report that he based his entire opinion on from 2006 said that 3 points of contact was the industry standard. He had to admit it. I asked him if he even read his report that he was lying. I took him directly to the page and showed him that the FRA said that 3 points of contact when riding a rail car is the industry standard. He couldn't get away from it. He had to admit it. And that report also said that remote control locomotives had a higher accident rate than conventional locomotives. And that the reports finding that the remote and conventional operations were virtually similar, that was based on major rail companies that had both robust remote and conventional operations at the same time. Major rail companies that had to have their safety rules on remote operations approved by the FRA, and major rail companies whose RCL operators had to be certified by the FRA. Remember that? The Sassel Sit Yard was the only remote operation that Savage had nationwide at the time of this incident. None of the Savage switchmen were certified RCO operators by the FRA. None of the safety rules over that sit yard were approved by the FRA. Go figure. Then something else happened. After Dr. Biz had no choice but to sit in his chair and admit that 3 points of contact was the industry standard, Sassel brought in his coworker from Exxon 2 days later, Elizabeth Van Roden, Rat Van Roden. And Rat Van Roden at the time she came in, she had been paid more than $40,000 before she ever showed up to this courtroom. And 2 days after Dr. Biz admitted that 3 points of contact was the industry standard, Sassel brought in this expert to accuse Justin of using 2 points of contact. Remember that? For the first time ever. Now he didn't have the hands on anything. Surfboarding on the platform at this point. 2 days after their expert had no choice but to admit that 3 points of contact, which everybody knew Justin was using, they bring in his coworker to tell you now he's doing 2 points of contact. Can't make this stuff up. Dr. Miss Rat Van Roden, she told you she had no rail experience. She told you that a 40 to 50 car train came to a stop with all rail cars stopping at the same time. Remember that? She admitted that she didn't know the weights of the rail cars. She said it didn't matter to her opinions, the weights of the rail cars. She even showed you an image of Justin standing inside the gauge, inside the 2 wheels. No other evidence in the case existed placing him inside the gauge. And when I pointed out that no other evidence supported their proposition, she told me that she's the only biomechanics expert in this case. Shameless. She couldn't tell you how far in front of the train Justin was thrown from a rail car, but said it would have taken him to roll faster than the Guinness Book of World Records speed to roll onto his back and land the way he was found. She didn't have the time to learn about slack forces. Didn't have the time to learn about buff forces or to understand how trains decelerate. But she was paid $40,000 and she went and read the Guinness Book of World Records. That's what Ms. Rat Van Roden did. She read the Guinness Book of World Records and crafted a way to place Mr. Francis inside the gauge where his arm couldn't even fit behind the arm rail. Had she taken measurements, she would have known that. So again, you are the sole judge of the witness's credibility. And I don't care how many degrees they claim to have, you can disregard or discount what they say if you find them to not be credible. Now you heard from Justin Francis, and you heard from him that he got his switch list from Sassel, that he performed his work based on Sassel's instructions, and that he did the job the way that was being done every day to support Sassel's $12.8 billion expansion project. That is control, not theoretical control, not partial control. That's forceful control, actual control, contractual control, iron-fisted control, day-to-day control. But with control comes responsibility. Responsibility to implement the proper safety rules, responsibility to protect workers, responsibility to protect workers from known dangers. And they had that responsibility. They had the knowledge, they had the ability to fix it, and Sassel chose not to. And Justin Francis paid the ultimate price with his arm, his dominant right arm being taken from him. Now, remember what Brandon Ogden told you. Now, Brandon Ogden was Mr. Francis's rail expert. He's the only expert in this case that had the rail experience that you need to work on a case like this. He worked over 20 years for a major rail company. You heard that unlike any other expert witness brought to you by Sassel, he actually ran remote control locomotives and conventional locomotives. He actually trained workers on remote control locomotives and conventional locomotives. He's not some academic scholar. Ogden is a railroad guy to the core. Ogden told you that when a 40-car train was decelerated immediately before Mr. Francis' incident, due to the makeup of the train, with some cars being fully loaded, partially loaded, others being empty, the slack forces caused Mr. Francis to experience a jerk that led to this horrible incident. And I want you to remember this video that we showed of how a train decelerates and comes to a stop. It's not like Ms. Van Roden told you, where all the cars are stopped at the same time. Now look at this slow motion video. These are slack forces. Every rail car pulling out, pushing in, stopping at different times, different weights, different loads. They're going to go faster than others. It's going to create, as he called, a bullwhip effect. These are the forces that you experience when a train, a 40-car train consist comes to a stop. It's not like stopping an automobile, okay? I think you heard that from Ms. Van Roden. Mr. Ogden relied on his experience, his site visit, and his study of the evidence to conclude that conventional locomotives would have been the safer option at the Sassel City Yard. Ogden also places control of this decision squarely within Sassel's responsibility, and he criticized Sassel for his refusal of Savage's request to switch to conventional locomotives. But I can tell you so much. Let's hear from Mr. Ogden himself.
But in my opinion, in this case, this was a very simple fix that could have been prevented just by the process of elimination, which would have been by far the most effective. And I have to ask myself as I reviewed through this material, why? Why didn't Sassel, prohibit remote control operations? Why didn't they make the change? And the only thing that I can keep coming back to is the same thing that sometimes in the railroad industry I see is that remote control operations save money. There are less people out there that you're having to pay. And that shouldn't ever come, that should never trump safety. And there's just the only logical reason that I can find why Sassel was so intent on holding Savage to this contract for remote control operations.
Now, the defense wants this case to be about justice. They want you to believe that all of this was his fault. But here's the problem with that. They can't point to a single safety rule that he broke. Not one. No written rule, no site-specific rule. No witness who could identify a single rule that he broke. Instead, what did you hear? You heard that what he was doing was how the job was done. was how he was trained to do every day in that yard. You heard that Richard Lee and Anthony Borland were out in that yard. Never had a complaint about it before. This is what happens when you get hurt. This is how the way he was operating a rail car on the day of this incident was how it was done every day in that yard with Sassel's knowledge, with Sassel's control, with Sassel's approval. So this is not a case about a worker breaking the safety. This is a case about a company failing to have it, failing to enforce them, and failing to fix known dangers. Now let's step back, because this didn't come out of nowhere, all right? You heard that this entire rail operating system that they were operating in the city yard was dangerous. Forces on the day of the incident, because of the makeup of the train consist, which he had no control over. He got a switch list from Sassel that morning and did what he asked, did what they asked him to do. The forces exceeded what he could resist, even with 3 points of contact. Because he was doing so much, trying to operate the train, trying to keep the lookout, trying to balance. Safer options exist. The concerns were raised and nothing changed. So ask yourself, what is the safety rule here? Is it use the dangerous method, hope nothing happens? Or is it when you know something is dangerous, you fix it? Because safety rules only work if they're followed. And when they're not, it's only a matter of time before someone gets seriously hurt. It's not a matter of how, it's a matter of when. Now, you also heard the suggestion that there was some evidence about a phone. And I told you at the beginning of this trial that was the biggest red herring that you're gonna hear in this case. And they brought an expert, and we brought an expert, and we looked at the facts, and you saw for yourself. But the evidence does not support that Mr. Francis was on the phone at the time of this incident. Let's have a look at what we know to have occurred. At 11:53 a.m., the phone record shows there was a phone call between Mr. Francis and his wife, Letitia. At 12:09 p.m., during that phone call, his wife receives a call from her cousin and puts Justin on hold. At 12:11, while he was on the phone, on the hold with Letitia, he made a call to his brother, Kendrick. Now, at 12:12, when Letitia's call with her cousin ends, Letitia is now on hold because Justin is on the phone with his brother, Kendrick. When Justin's phone call ends with his brother at 12:17, they're both on hold. You heard their own expert come into this courtroom and say that once 2 phone calls in, you're back on hold. Further action needs to be taken. Justin was on the phone with his brother. Letitia was on the phone with her cousin, both of them on Bluetooth earpieces. Justin was in the parking lot, sitting on his truck after he had filled up some water, because they need water. He'd already gotten started on his work that day. They had gotten the switch list late that morning. Justin puts his phone in his pocket. He's on the earpiece. Takes the earpiece out, puts in his ear protection, goes back to work. 12:17, he's off the phone. He's got his ear protection in. He's going back to work. The data in this case shows 69 seconds of movement to have occurred when this incident happened. From 12:17 to 12:28, when the phone call was made to his boss, is a window of time when this incident occurred. I couldn't get their expert to agree to that. Now, we showed you what was going on between Justin and his brother. There was 2 purchases being made. He using his phone to buy some shoes for his brother. His brother sent him cash apps and all of this stuff. The expert that they hired would not even agree that the incident didn't happen in 12, 15 minutes. Take that off of the range that you built out. He wouldn't do it. He wouldn't do it. Can't make this stuff up. But the phone call between Justin and Matisha, which, to be honest with you, is one of the miracles in this case. This is something that up until last November, this family talked about as being a life-saving event. Wasn't until November of last year when suddenly there's an accusation of him being on the phone. Everybody's a liar. Justin's a liar, his wife's a liar, his brother's a liar. What does the data tell you? What does the phone record say? Justin told the story. That's one of the most touching stories we've heard in this trial, where he's trapped under the train. He's looking for his radio with his foot. Imagine it. Imagine it. Trapped under the train, all alone, thinking that you're gonna die, looking for your radio that had been ripped off of you during this horrible event. And something tells you to look at your watch and you see that you're on the phone connected to somebody. He didn't remember who it was. What he was going through is what he testified to. He reaches in his pocket, he pulls out his Bluetooth earpieces, and as he puts it in, it reconnects, and he said it was Matisha. It was his wife. Imagine that. That's being turned against him and used against him to accuse him of being on the phone. So he's on the phone, he's inside the gauge. Shameless. This is what's going on right now. Their own expert told you that being connected on the phone records, where we showed you the codes that showed you that people were on hold, the connected call does not mean that he's talking actively on the phone with anybody. Their own expert sat there and told you that. But they're still pushing that theory, the biggest red herring in this case. Now I want to talk a bit about damages, okay? But before I do, I want to talk about the jury questions that you're going to have to answer. And the judge went through the jury charge with him. You're going to be asked on the first question in this case, presented to you evidence. Did Sasser Chemicals exercise actual or retain contractual control over the manner in which Justin Francis operated the remote
Counsel,
control?
approach, please. Take that off the screen.
All right, I'm gonna read you. You have the jury charge here in front, okay? Did Sasser Chemicals exercise actual control or retain contractual control over the manner in which Justin Francis operated the remote control locomotive on the occasion in question, other than the right to order the work to stop, or to inspect the progress, or to receive reports? That's the question that you have before you. That's the question that you're gonna have to answer. This process for all of you that you'll be tasked with doing as our honorable jury begins with a yes. It begins with a yes. Justice requires a yes on this question. You've heard the evidence. Did Sasser Chemicals exercise actual control or retain contractual control? Everything you heard about why Justin Francis was operating a remote control locomotive on the day of this incident was that a contract is a contract. A deal is a deal. Alec Rier sat there and told you that. Mike Curligan sat there and told you that. Richard Lee sat there and told you that. Anthony Borland sat there and told you that. The entire reason that a remote control locomotive was being used on that day, when Mr. Francis's company requested that it not be used on that day, was because of a contract. And that's not his fault. That is contractual control by definition. That is the deal. A deal's a deal. You signed it, you gotta do it. Now, what you heard from Mike Hurligan was that the circumstances of the CPR had changed. This was an expansion that was going on. All of these new units were coming online at this time. There's more production. The month of March in 2021 was the largest month of any month at that time in that CPR. You had 1,388 rail cars with a capacity of 1,500. And some of the documents you'll see says 1,400 as capacity. These guys were doing 1,000 switches a week, I think is what Troy Savage said. Tons of work happened as a result of this expansion. It no longer was suitable for the use. Rail cars, remote control locomotives, no longer got it done. You got to pull 40 to 50 car trains at this point. The city yard is overcrowded. You need conventional at this time. And Savage, who Sassel told you, their lawyers at the beginning of this trial told you, we're a chemical company. When are they going to stand on that? When are they going to say that again? We're just a chemical company. Savage is the expert. Well, the experts suggested that you go to conventional. And they use that contract to force them to continue using remote control. That's the reason why justice requires that this first question be answered as a yes. The second question that you're going to have to answer, did the negligence, if any, of Sassel Chemicals in exercises or retaining that control, you found in the answer to question number one, approximately caused the injury in question. Now you have these definitions that the judge went through with you, define the negligence, ordinary care, and failing to do what a person of ordinary prudence in the same or similar circumstances would do. Think about a person in the same or similar circumstances. Think about a switchman on that CDO. What would they do? They would follow the rules. They would do what they were trained to do, just like Justin did. But when you talk about negligence, from Sassel's perspective, you got to talk about not a person, you talk about a company at this point. We're looking to Sassel's negligence in this question. And that's the reason why justice requires a yes. It all begins with yes. I need 2 yeses. Justice requires 2 yeses from you in your deliberations. Sassel's negligence approximately caused Mr. Francis's injury. Their requirement that Savage continue to use these RCLs, their requirement that Savage use these RCLs, knowing that the rules that were being imposed on riding these RCLs with 40 cars at a time, 50 cars at a time, some of them loaded, some of them partially loaded, some of them not loaded, is going to subject their riders, their workers to slack forces. Their failure to prohibit that practice is what caused this incident. Their failure to adhere to the suggestions of the rail company, which was Savage, is what caused this incident. That's the reason why Mr. Francis was operating an RCL on the day of this incident. That's the reason why he fell from the RCL. That's the reason why this incident happened. Yes, that's the question number 2. Number 3, now you're looking at the negligence of Justin Francis and Savage. Now, justice requires a 0. A 0 on this first line as it pertains to Mr. Francis. He did nothing wrong. I can say that with a straight face. He followed the rules. He did exactly what he was trained to do. Not gonna blame this on this man. Now, if you want to put some negligence on Savage for not breaking the contract, they tried. They tried. But if you want to put negligence on Savage, then that, give them a yes. But you need to know as to Justin, no as to Justin Francis. Justice requires a no as to Justin Francis. go ahead and put a yes as a Savage. Because, and if you don't feel that if you feel like they did enough by trying and by bringing and suggesting and going to the owners, Sassel, and saying, hey, we want to use conventional, do what you feel, but no as suggested. Let's look at the next question. This one says that if you answered yes to question number 2, which was as to Sassel, or to either, yes to either of those questions in question number 3. So if you answered yes as to Justin, which you shouldn't, or if you answered yes as to Savage, then you go to this apportionment page. Okay, and this question number 4 is where you assign percentages. On this line, and any line where you write a no, write a 0. Justin Francis is a no, Justin Francis is a 0. And if you want to attribute some responsibility to Savage, I suggest to this jury that it be at or below 10%. 10%. Because they were not in control. There was nothing that they could have done to convince Sassel. You know why Sassel wanted. Brandon Ogden told you why Sassel wanted to continue operating those RCOs out there. So Savage went to him and said, let's go convention. In a meeting. And Richard Lee came in here and on the stand under oath and tried to lie about it. But we caught him. We caught him. So 10% or less for Savage, which leaves 90% or more for Sassel Chemicals. Justice requires 90% or more for Sassel Chemicals. We brought you the evidence. They exerted control. They exercise actual control. They exercise contractual control. A contract is a contract, a deal is a deal. 90% or more on Sassel. So now, I want to use the rest of my time to talk to you about damages, okay? Because this case is not only about what Sassel did. This case is about what Sassel took. And when safety rules are broken and trust is broken, the harm doesn't stop at the moment of the injury. It continues. It continues in the body. It continues in the mind. It continues in the future. My co-counsel told you at the beginning of this case that Mr. Francis has at least another 40 years to live. 40 years to live. This way. Every one of us lives our lives trusting that the basic safety rules will be followed. We trust that systems are designed to be safe. We trust that known dangers are going to be fixed. We trust that companies will not ignore risk, okay? Because if that trust is broken, none of us are safe. None of us. And when that trust is shattered, and the harm is not just physical, it's emotional, it's permanent, and it changes how a person lives their life. This is what happened to Justin Francis. This injury didn't require minor treatment. This was life-altering, life-saving care that he had to undergo when he arrived at the Lake Charles Memorial Hospital. Care that was needed because safety rules were not followed. You heard something that many of us in this courtroom have called the moment. We believed he was going to die. It's not something the person just moves past. Not. That stage. This injury did not end for him on March 7th. And it will not end when this trial is over. Because permanent injuries cause permanent consequences. They carry permanent consequences. Ladies and gentlemen, we talk about this loss in big terms, injury damage numbers, but it's not where the real loss lives. It lives in the quiet, ordinary moments in a man's life. Okay. For this, he was a father who could reach out with both arms to his child and close without thinking. A husband who could hold his wife and make her feel safe. A man who could fix things, carry things, build things, who could simply show up for his family in all the ways that matter. And now, every one of those moments are different. But now, tying this child's shoe isn't that simple. Cooking a meal isn't easy. Carrying groceries, fixing things around the house, helping with homework. Everything takes more time, more effort, more thought. Some things you used to do without even noticing, and now Justin struggles to do it all. And there's something deeper, something that's harder to say out loud. You know, Justin, as a man, is his role as a protector. You heard him talk to you about that. Because when you're a father, when you're a husband, protection isn't a title, it's an instinct. If something goes wrong, you act, you reach, you grab, you shield. But now even that has been taken from you. In an emergency, when seconds matter, when your child is hurt, your family needs you the most, he gets behind the wheel knowing that he no longer has the same control, the same ability to react, the same safety he once had with two hands to guide that vehicle in an emergency situation. And that changes something inside of him. It does. But it's not just about what he can do. It's about what he can no longer promise the people who depend on him. Certainty, security, quiet confidence that says, I've got this, I've got you. And he feels that every single day. This isn't just the loss of Norm, this is the loss of ease, it's the loss of independence, the loss of the role he lived in his own family, the loss of the man he was in those ordinary, irreplaceable moments. And now the law cannot give him his arm back. But the law requires what justice demands, and the full weight of that loss must be recognized at this point. Not minimized, not discounted, not treated as something small because it happened quietly, because it happens quietly day after day for the rest of his life. And you are asked to measure something that many people think can't truly be measured. But think about what this loss means, not for a day, not for a year, but for every single day he wakes up for the rest of his life. 40 years, decades of limitations, decades of struggles, decades of being reminded in the smallest of moments what was taken from him. What's that worth? What's the worth of losing full use of your body? To lose the ease of caring for your children, to lose the instinctive ability to protect your family, to lose in so many ways the life you once lived. When you consider the permanence of this harm, the scope of it, the lifetime of it, the only full and fair verdict, the only full verdict that recognizes what was taken is one that's in excess of $50 million. Understood. Not because that number can replace what he lost, but because that is the only way that the law can fully acknowledge the magnitude of that loss. And your verdict is the voice that says that it matters. So I want to go to the damages. And you'll be asked on the first two questions of damages. What is the value of physical pain and mental anguish? You have definitions that our honorable judge has already read to you. You remember that what he went through in the immediate aftermath. And these are the numbers that you should write on this line. It's been 5 years since this incident. Each and every one of these damages lines requires a full value. A full value for what he's gone through. Emergency response came out 30 minutes trapped under the train at least. Helicopter transport, trauma care, the surgeries. You heard Dr. Balazi go in graphic detail about what this surgery required. You heard about the fact that this lower portion of his arm had to be clipped off because he had about a 10%, it was a 90% amputation at the scene. They had to clip off the remaining 10%. They discarded it in a bag. You heard from him, the pain he felt was the worst pain he's ever felt in his life. He described it as sounding like a bag of chips being crushed together. Every bone, every bony structure, every neurological structure in this man's arm was crushed by a train. And he was trapped there for 30 minutes. That's pain, that's mental anguish. That's $6 million in the past, and in the future, for 40 years, he talked to you about phantom pains that he still feels daily. This man still feels pain in a limb that he no longer has. His hand is burning. He's still dealing with this today. He will be dealing with it for the rest of his life. It's been 5 years, guys. $10 million, at least $10 million physical pain and mental anguish in the future. Let's go to the next slide. The loss of earning capacity, you heard from Bill Alexander. He was the expert economist. Bill Alexander gave a very conservative amount for loss of earning capacity. Mr. Francis, you heard from people in this trial. Casey Turner is what I believe her name was. And she came into this courtroom and she gave you a list of jobs that she thinks Mr. Francis can do. I asked her if she knew whether those jobs were available. One of the jobs was a casino security guard. This is Texas, by the way. Casino. She gave you median wage amounts. I asked, what's the entry level? Mr. Francis, and I asked her point blank. So don't let these lawyers come up here and tell you different. I asked her, are you telling this jury, based on what you know about his work history, that this man is a freeloader, that this man is looking for something for free, and that this man is lazy? And she had to say no, because she knows this man's working history. This man has always worked. He's never been a freeloader. This job to him over at Savage was an opportunity to get a foot in the door. He was going to parlay that job into a bigger job. He came in as an entry level, making $17 an hour, the most money he'd ever made in his life at that point. Within 3 years, he had moved up to the league. Within 1 year, he had moved up to the league. Within 3 years, he had qualified to be a yard master. 26 years old was when he started. When this happened, when this incident happened, he had already gotten married to his wife 3 weeks until they were going to have their official wedding. 29-year-old man. Look at the maturity there. Stable job, married his wife. This is a future, a working career future that he chose. He didn't have a college degree. You don't have to have a college degree. My dad didn't have a college degree. This was the career path that he chose. And he was on his way. That was taken from him. How dare somebody try to get up here and call this man lazy? He's going to have it hard going forward. He's going to have it hard going forward. He's going to have to get somebody to give him a chance in a position that he's never had before a day in his life. Entry level. He's going to have to learn a new trade. He's tried. He's tried. But you know he's going to have a tough time. He's going to have a tough time. Somebody's going to have to take a chance on him. This lady came into this courtroom and said initially that he could be a yard master. Not going to happen. Yard master is a switch. You got to go through a switch. The opportunity is gone. He's going to have to start from scratch. But just as a fighter. The loss of earning capacity that Bill Alexander told you about in the past, he's already lost $309,430. In the future, the gross is $817. If you believe that he's going to be employable at some point in the future, then I believe that. Reduce $817. That's the most that we're asking you to give him in the future for lost wages. Okay? But it's up to you to decide. Let's go to the next slide. Disfigurement In the past, disfigurement, you see the definition of that, and I'll read it to you real quick, just to remind you, I don't think there's gonna be any question. Disfigurement is that which impairs or injures the beauty, the symmetry, or appearance of a person or thing, that which renders unsightly, misshapen, imperfect, or deforms in some manner. He wears it. He's been wearing it throughout this trial. That's disfigurement 101. By definition, disfigurement in the past for 5 years, that's $5 million. The disfigurement for the foreseeable future in 40 years, for the remaining 40 years of his life, you heard the stories about the embarrassment. You heard the stories about the pictures that he's taking, that he takes right now, hiding his arm behind whoever he's taking a picture with. You've heard that this man shops for groceries out of town because he doesn't want people to see him this way. And if you want to talk about embarrassment, remember that picture that Anthony Gordon took? I asked him point blank about that. He lied. I asked him, did you take this man's picture? He said no. Justin looked him in the eye. There's a picture of this man in his most vulnerable state. $10 million in reasonable probability disfigurement damages he will sustain in the future, at least. Let's go to the next slide. Physical impairment, this is the most important damage component that applies the most to Justice Francis. Okay? The definition means a lot, means a loss or diminution of the injured party's ability to engage in tasks or activities for one's own benefit or enjoyment. In assessing the damages for physical impairment, you must consider the loss of enjoyment of life. The effect of physical impairment must be substantial and extend beyond any pain, suffering, mental anguish, loss, wages, and the past. Impairment is everything this man deals with every day. When this man got up to come to court this morning, his wife buckled his belt. This man won't be climbing ladders. This man won't be climbing ladders. This man won't be climbing ladders to change light bulbs. He won't be climbing ladders to put the Christmas tree on Christmas. That's impairment. Every time he eats, he says he has to chase his plate around. The damages for a physical impairment, $7 million in the past, $12 million in the future. 40 years without your dominant arm. The total amount of the damages that we've presented to you today, when combined, is at least $51,126,560. This is the full and fair amount of Mr. Francis's claims. The judge instructed you not to punish them. This isn't punishment. This is a full and fair verdict. Look at what was taken from this man. The rest of his life, look at what was taken from this man. That's Mackenzie, that's Major, that's Jeremiah, that's Drew. Justin is somebody then. Justin is somebody then. He matters. I thank you so much for your time. I'll have a few more moments with you after the pending goes. But you were doing an amazing service, and I really appreciate the evidence that you spent monitoring, looking at, studying the evidence in this case. It's been my pleasure to present my case on your behalf. And I'll be back in about an hour and a half. Thank you.
Ladies and gentlemen of the jury, at this time, we're going to take a brief recess to allow us to reset in the courtroom and prepare for Sassel's closing argument. I will also give Ms. Coronado an opportunity to rest her fingers before we deal with the next portion of this. It is about 11:35. We will try to reconvene in about 10 minutes at 11:40. We will remind you that you heard the charge and some of the closing arguments and the evidence. You are not to discuss this case amongst yourselves or with anyone else.
All rise for the jury. Get through the sheet here, the charge sheet.
Council will pick this up in about 10 minutes.
All right.
Oh, she. Oh, yeah, no problem.
Where do you? Yeah.
Yeah.
No,
Just over here.
no, I don't think so. You should down
Okay, yeah, sure. Yeah.
Board
let's do
number
that.
and then she.
Where's our other one?
Yeah.
I wanted two of these.
Perfect.
If we got them.
So you're saying.
Text me and
Okay.
then I'll.
Or I can just use it post-
And I'll confirm with you that she's gonna be there.
I'll let you put it.
Oh, it's right there.
Ah, there we go.
Of course, yes, I go straight to it rather
Put it right here.
than. So I'm gonna give her your number and then I'll. Thank you.
There you go.
Okay, one. Say, while we're. I mean. You just make it.
What colors do you want?
Okay, red, blue. On this one.
That one doesn't have a tray.
And, in green. And black. Or black. I got black here. Will this work on these things? How can I?
Over here, space.
And then I gotta walk a long way back and forth.
On my notes.
Just puts it on the wrong side for me to really right. What do you think? This is gonna stay on one page. I can put the board up here. I'm not gonna do this on. Well, I'm running out of space.
Put it anywhere. Back that way. Do you want me to leave it over there? Just in case?
Yeah, leave it back that way. I can figure it out. Where's the other one you made that I said I might be able to use?
Get it.
So if I stand here. Stand here. Notes. I can work with this one. I'm on the wrong side. I'm gonna have to come in front of it, but. Otherwise, I gotta be by my notes. Yeah. Then I can just come over here. Every time I have a meeting. Right here.
Restroom. We're ready to roll.
in a moment, but I want to start by talking to you about things that there's no basis for disagreement. Things where the evidence truly is absolutely conclusive and the facts are indisputable. So what's beyond dispute? Number one, Sasol is in fact a chemical company. And Savage is a rail switching company. Nobody's disputed that from the very beginning. And that's important when we take a look at who bore the responsibilities for what. Number three, Mr. Francis only worked for Savage. He never worked for Sasol. Number four, Mr. Francis, and by the way, I don't want you to take my word for it at all. I want you to be guided by the evidence, and I'm going to show you the evidence. And what I'm showing you here is not a PowerPoint that I created with what I think or I say somebody said. What you're looking at right here is the exact record of what Ms. Coronado says they said from right there in that stand over the last 3 weeks. And that's what you're going to continue to see every time you see something that looks like that. That is the actual word-for-word transcript of exactly what they said. And again, this is from Mr. Francis's testimony. The entire time you worked, you always worked for Savage. Correct? Correct. Four, Mr. Francis was only trained by Savage. And again, Mr. Francis acknowledged it. Regardless of where it happened, all the work plate training you received for this job came from Savage. No surprise there. No surprise here that all of his training manuals and his rules came from Savage, not Sasol. And there's one in particular. This one's obvious. We've heard a lot about it. We're going to keep hearing about it. Defendant's Exhibit number 1, the rail operating manual. There's one that I think people are being a little bit intentionally vague on when they shouldn't. It's the site-specific manual. This is a Savage document. And if you go to page 3, you can see how. Under services we provide, we, who's the we? Savage Services. This is their document, not Sasol's. They are responsible for everything that's in it and everything that's not in it. And of course, if you look at who updated, Matt Moyer. Testimony is clear, unequivocal. Matt Moyer worked for Savage, not for Sasol. While we are here, I want to point out one other important point from this that we'll talk about later. It's on page 2 of this document that's also in evidence. Nice reminder, site-specific rules can only be more restrictive than what is currently in the ROM. The ROM, again, being the Rail Operating Manual. Keep that in mind. Something else that's beyond dispute is what we know Mr. Francis knew as of the date of the incident. What do we know he knew? Number one, we know he knew the Rail Operating Manual. This document contained the minimum rules required for safety. Number two, that these were both safety rules and safety expectations. Number three, it is imperative as a Savage employee that he follow the rules in the rail operating manual. Number four, if you don't follow the rules, again, in the rail operating manual, you could get hurt. And finally, he knew as of the date of the incident, if there's a more restrictive rule and a less restrictive rule, you follow the more restrictive rule. He knew it. So what else is beyond dispute? Mr. Francis is a man who uses his cell phone while he's working. That's beyond dispute. The evidence has shown it. We heard from experts and we also heard from the witnesses. We looked at the phone records and here's what they show. My colleague, Mr. Tibbs, put up a chart. This is the day of the accident. Not exactly the time of the accident, but this is the day of the accident. This is all undisputed. These are the amount of time that Mr. Francis, according to the phone records and the testimony, was on his phone while working. And ladies and gentlemen, yes, I'm not yet talking about the moment of the accident. We're going to get there. What this shows, an hour and 28 minutes in a period of only about 2 hours and 20 minutes. This shows conclusively that Mr. Francis is a man who routinely and repeatedly uses his cell phone while he's at work, which also means he routinely and repeatedly violates some of the most fundamental and critical safety rules associated with his job from the rail manual. Section 1.2, rules prohibiting cell phone use. Now, folks, these calls didn't all happen on ice breaks. These calls didn't all happen on bathroom breaks. They didn't all happen in a parking lot. You didn't get breaks for an hour and 28 minutes that morning. These calls were made, at least in part, if not completely, while Mr. Francis was in the sit yard, switching trains, doing his job. There is simply no way to dispute that. The evidence is simply conclusive. Now, here's one that might surprise you. It's undisputed that there is no documented complaint or warning or request or recommendation to switch from remote control locomotives in the sit yard before this incident, before March 7th, 2021. Now, plaintiff has done a lot talking about documents and showing you a lot of documents. Really only two documents where Savage mentions to Sassol, we want to change to from remote control. The key point here is the dates. The dates on these documents. The first document is the draft action plan, the draft RCA, our root cause analysis after Mr. Francis's fall. It's analyzing Mr. Francis's fall. It had to have happened after it fell. And this is only the draft, as you heard. Savage changed it. And the second is the letter. Again, look at the date of the letter. Look at the date of the letter itself. We can pull it up. January 28th, 2022, after the incident. I'll promise you, you can look through every document you're going to get back in the jury room. You will not find one where Savage, in writing, came to Sasol and said, we want to switch from remote control locomotives before this date. It doesn't exist. It's not in evidence. Now, you will, however, find documents. And the biggest ones are this 128 meeting. This big January 28th, 2021 meeting. And we've got two documents here. One created by Savage and one created by Sasol. Savage document is their presentation that day. Plaintiff's exhibit number 2. And you can flip through it back there if you want. We'll flip through it slowly here. Not a single mention. Not one mention of remote control locomotives. And this is the big safety meeting that you've heard about, where all safety issues are going to be discussed. Not one. Not a single mention. In their presentation, does it make sense that if Savage was hounding Sasol to get rid of remote control locomotives prior to this incident, and they were granted a high-level executive meeting with the highest level people from Sasol and the highest level people from Savage, including Troy Savage himself, does it make any sense that they wouldn't once put the issue of remote control locomotives anywhere in their presentation? It doesn't make any sense at all. Or does it make more sense that it's not in the presentation because they weren't complaining about the RCLs until after the accident? Yes, I know there was a conversation that occurred there, and we'll get to there. But plaintiff wants you to believe somehow there's this big conspiracy to hide all of these complaints. Here, neither Savage in their document, nor, we can pull up the minutes, Sasol in their document, ever mention remote control locomotives. The presentation doesn't cover it, and the minutes don't cover it. Does it make any sense that somehow Savage and Sasol are both conspiring together to hide a major topic of this meeting? It doesn't. Does it make more sense that the reason the documents are silent is this wasn't a topic at this meeting? That's a question for you. So remember, at the very beginning, I talked to you about the concept of red herrings. Remember the definition? I actually looked it up. A piece of information intended to be misleading or distracting and designed to trick you into an incorrect conclusion. I promised you in voir dire this case would be full of red herrings. It is. Red herring number 1 is documented complaints about RCLs. They don't exist prior to the incident. Now, what else is undisputed here? How Francis did his job was up to him. Up to him. Not up to Savage, not up to Sassel. How he did his job is up to him. And we know two things already about how he routinely chose to do his job. Number one, we know from the phone records from that day that he routinely chose to do his job while on his cell phone. There's no other way to explain that much cell phone time in the middle of a shift. And two, and even more importantly, on the specific part of the job where he fell, Mr. Francis chose to ride the rail car. He didn't have to ride the rail car if he didn't want to. He chose to ride the rail car. Now, ladies and gentlemen, I'll submit to you that just the undisputed facts here, the undisputable facts here, tell you all you need to know, which is that Sassol didn't do anything to cause this incident, but Mr. Francis did. Now, I want to turn you to the disputed facts. And I want to remind you that under the instructions the judge has just given you, you're bound to render your decision based on the evidence and the evidence in alone, in accordance with all of the law and the instruction the court has given. Now, I'm not going to sit here and spend my time just reminding you of all the evidence that you heard. You sat through it, you heard it. What I want to do with my remaining time is talk to you about how the evidence relates to the questions and how the evidence supports or doesn't support certain answers to the questions. So let's go to question number one. Pardon me for saying something obvious, but all questions are made up of words. And words matter. Every word matters in a question. And question number one is a prime example. Look very carefully over what you're being asked and what you're not being asked in question number one. Did Sassol exercise actual control or retain contractual control over, and here's the key, the manner in which Justin Francis operated the remote control locomotive on the occasion in question? You are not being asked, did Sassol exercise actual control or retain contractual control over the manner in which he moved the train? It's the manner in which he chose to use the remote. Why? Because the manner in which he moved the train, actually using a remote, didn't have anything to do with the accident. Now let's think about that for a moment. How could the manner in which Mr. Francis used the remote control system have actually contributed to the accident, conceivably and theoretically? Well, number one, it could have contributed to the accident if the remote control put him on the train. Because obviously you can't fall off a train if you're not on the train. But we know that isn't true, because Mr. Francis testified specifically about how and what he did in this job immediately leading up to his fall. Now, remember how I had Mr. Francis explain to me how this job worked, because I don't work in a rail yard and I'm not the smartest guy in the room. And he helped explain to me that there were two parts of this job, okay? And look at the top, I put all this up there to be fair. We're talking a little bit about the job he was doing when the incident happened. There were two parts of the job. A pull, when the engine's pulling the train, point A to B, and then a shove, which I incorrectly called a push. A pull from A to B, a shove from B to C. Very fair, Mr. Francis says. Two halves of the same job with the same train in the same sit yard with the same remote control system. Just going from point A to point B to point C. But there was one critical difference. On the pull from point A to point B, Mr. Francis was on the ground. On the pull part of the job, you were not riding the rail car. On the pull part of the job, you were on the ground. Ladies and gentlemen, if Mr. Francis could use the remote control system to move the train from point A to point B on the ground, he certainly could have used the remote control system to move it from point B to point C on the ground. It's the same train. It's the second half of the same job. The bottom line is the remote control system did not put Mr. Francis on the train. So how else could the remote control system itself have been an issue here, as opposed to how Mr. Francis used it? Well, if it put him inside the gauge. Because we know, and we'll get to this in more detail, the only way he falls by the laws of physics to where he can be run over by that train is if he starts from inside the gauge. No one is alleging, and there is no evidence, that the remote control unit made Mr. Francis somehow stand inside the gauge, inside the rails that day. So let's go back to the question. Did we retain actual or contractual control over the manner in which he operated the remote control that day? The answer is clearly no. Now, what would plaintiffs have you believe? What evidence do they point to here? Well, they point to a lease agreement between Kansas City Southern and Sasol. Well, folks, you don't have to be a lawyer to know that a lease agreement, like any other contract, defines the relationship between the parties who signed the deal. Nobody else. This is an agreement only between Kansas City Southern and Sasol. It has nothing to do with Savage or its employees or anybody like that. Now, if you want to understand the issue of control between Savage and Sasol, you look at Defendant's Exhibit 27, which is in evidence. Here's where the relationship between Sasol and Savage is defined, and here is the key language. While Sasol has the right to instruct the contractor as to the results to be obtained, the contractor, who is Savage, has complete control, supervision, and direction of the methods and manner for obtaining such results. Ladies and gentlemen, the KCS lease is the second red herring. Now, what about the she handle? The Sasol contractor she handle means just what it says it means. That contractors can't create programs that are below the minimum global standards that Sasol applies throughout its plant. What does plaintiff want you to think it means? That somehow the she manual controls how Mr. Francis operated remote control. Well, you can look all through this. You're not going to find any instructions, any rules, any prohibitions about switching cars or operating a train. It's not there. There's nothing in here to which the Sasol rules would be subordinate, as plaintiff likes to point out every time. This has nothing to do with anything here. It's another red herring. based on the evidence, the question you are asked can only be answered in one way. Sasol did not, in fact, exercise actual or contractual control over the manner in which Justin Francis operated the remote control locomotive on March 7th. The manner in which he operated it was up to him. And Mr. Francis testified he rode because he wanted to. He rode because he chose to. Sasol had nothing to do with that. Sasol exercised no control over that. Again, the answer to question number one, based on the evidence, must be no. Now, if you answer question number one, no, as I am confident you are, because that's the only answer the evidence will support to this question as put to you by the judge, you don't get to question number two. But from this point on, I got to do my job, and I just can't let you go to lunch that early. I'm going to go through some of these questions, even though you're not going to get to them. And again, show you how the evidence relates. So let's look at question number two. And there are two really important points in this question. Number one is asking if there is any negligence on the part of Sasol Chemicals. Negligence is failure to use ordinary care, failure to act reasonably. And number two, did it proximately cause the injury in question, meaning it was a substantial factor in bringing about the injury and without which the injury would not have occurred. That's really key, because what's important for you to understand is someone can act unreasonably and still not be a cause of anything. Now, I'm not saying anybody from Sasol acted unreasonably. Let me be 100,000% clear on that. But that's an important distinction, that there are two parts to this question. And it's important you remember that when you consider this question, if you do, which you won't, because you're going to answer no, question number one. Let me give you an example. And this is not the best example because it involves unreasonable conduct, and there's none here by Sasol, but it's the best one I got. So let me give it to you anyway. Let's say you are speeding, 100%, you're speeding down a road. You come to an intersection with a stoplight, and you have the green light. Someone runs the red light and hits you. Now, you were speeding. You were driving unreasonably, but you didn't cause the accident. Your speeding didn't cause the accident. The other person running the red light caused the accident. So even under that example, where there's 100% clear unreasonable conduct on this question, the answer would be no. So let's talk about how you should analyze this question and what it means. Now remember again, Sasol didn't run the sit yard. There's no evidence of it. It didn't employ Francis. It didn't train Francis. How do you get to an answer on this question? There's 4 steps in my estimation that you have to go through. Step 1, were RCLs unsafe? Well, ladies and gentlemen, the evidence is very clear. They're not. You heard from Mark Viz, who came up here live and testified that the Federal Railroad Administration has reported that RCLs are just as safe as conventional operations. Here's his testimony. The American Association of American Railroads, the largest and most influential railroad industry group for 100 years, says they are proven to be as safe or safer than conventional methods. And again, they're safe if you follow the rules. Now, plaintiff says they're unsafe. Based on what? Well, they have a testimony of Brandon Ogden, who I will remind you, 98 plus times out of 100, he testifies on behalf of a plaintiff. And he says they're unsafe. As I understood the evidence, there's really only two other reasons they're saying they're unsafe. Number one, you can't maintain 4 points of conduct or contact while riding on the back of a rail car and operating an RCL. And number two, that plaintiff was using one at the time of his fall. So let's think about that. Number one, you don't have to worry about 4 points of contact with an RCL if you are on the ground while you use it, like Mr. Francis did on part one of the very job on which he was injured. You can certainly also maintain 4 points of contact with the train while you're using the RCL. You just can't do it from the spot Mr. Francis chose to ride. It's been a lot of testimony that you can do this in the cab. Ladies and gentlemen, the bottom line is this. There is no credible evidence that RCLs are inherently unsafe. There's a massive amount of evidence that the plaintiff used his RCL in an unsafe way. But ladies and gentlemen, anything can be unsafe if you use it in an unsafe way. The fact that the plaintiff used the remote control system in an unsafe way is not evidence and does not establish that the remote control unit itself is unsafe. When used appropriately, it is safe. So if you come to the decision, no, RCLs were not unsafe, you're done. You put a no to Sassel. Let's say for a moment that you don't buy it. Don't buy it, Kevin. I don't like RCLs. I do think they're unsafe. Well, then you have to come to step two, which is, did Sassel act unreasonable in using it? And here we come to the undisputed evidence that we've talked about before. Remember the reason that Sassel first started these RCLs. It was because of a death that happened years and years ago from a man riding a rail car to try to get workers off rail cars as much as possible. Not all the time, but as much as possible. Go back to the evidence about when people were actually complaining about this. When they were actually complaining about these. It's all after this incident. Now again, the big January 28th, 2021 meeting, we've looked at the documents. The Savage documents don't show even a mention of remote control locomotives. Neither do the Sassel documents. The only evidence is a conversation, passing or otherwise, between Richard Lee, the number 2 guy in logistics, and one Savage employee about possibly going away for RCLs for efficiency's sake. 5 weeks before the accident, instead of bringing it up as part of their major presentation, somebody mentions it as a possibility. 5 weeks beforehand. What are we supposed to do with it? The second in command gets one verbal, hey, we might not think about this, 5 weeks before the accident. Is it reasonable to say, shut the whole sit yard down based on that? No, it's not. Even if you don't like remote control locomotives or don't think they are as safe as conventional, even though there's no evidence of it. There's no evidence that Sassol, as a chemical company, was unreasonable in using them. Other people were using them. Savage was not complaining about it before the incident. So if you get here and you answer no, Savage was not unreasonable, again, you're done. And you put a no to Cecil. But let's say you put a yes. Here, still don't buy it, Kevin, still don't buy it. Then you have to answer the causation part of the question. Step 3, did the RCL put him on the train? And we've already been through this. The answer is absolutely not. The RCL did not and could not have put Mr. Francis on the train that day because he walked part 1 of the very same job. So the answer here, if you say no here, it's no to Sasol and you're done. If you say yes, you're still not done. Somehow, some way you think the RCL put him on the train? One more step. Step 4, did the RCL put him between the gauge? Terrible. Because look at the question again. The question asks you whether it proximately caused the injury in question, not the fall, the injury. The injury is the loss of his arm. And the evidence is conclusive. The only way Mr. Francis falls in a manner in which he loses his arm is if he starts from inside the gauge, inside the rails. Remember what Dr. Van Roden told you. While Mr. Francis is on the platform and it's moving, he and the train are one. And then when he falls off, he continues to move in the same direction as the train. He doesn't corkscrew, he doesn't spin. If he starts outside the gauge, he ends up outside the gauge. Look at this picture of the actual tank car that's in evidence. If he's at the very edge of that gauge and he falls in the same direction as the train car, he falls outside the gauge. And there's no time and no possibility of him rolling up over those timbers and over those 7-inch rails to get back onto the track in time for him to fall. So ladies and gentlemen, even if you think yes, 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 yes here, the answer here has to be no. And once again, it's no to Sasol. Only 4 yeses to these 4 questions will enable you to put a yes for Sasol. RCLs have to be unsafe. Sasol had to be unreasonable in using them. The RCL had to have put him on the train, and the RCL had to have put him inside the gauge. There's no evidence to support that. Any off-ramp you take, any no, under the evidence and the law, mandates an answer of no for Sasol. Let's talk about question number 3, about Mr. Francis and Savage. Now here, you're evaluating Mr. Francis first, and you're evaluating Savage. And here, it's important to remember what plaintiff told you about, which is that you are the sole judges of the credibility of the witnesses. Some witnesses have high credibility, some witnesses have low. It's up to you to decide. If you find Mr. Francis to be a credible witness, you may come to certain conclusions on this question. If you don't find him to be a credible witness, you may come to other conclusions. That is your decision. Now, I'm going to say up front, I'm not trying to be disrespectful or insulting. But ladies and gentlemen, facts are facts and testimony is testimony. And I want to remind you of some of the things that Mr. Francis testified to under oath here. Number 1, testified that Acadia showed up first at his scene. the outside paramedics. We know that's not correct. Both Eric Hanslet and Joel Thompson testified they were there first, and that's what the documents show. The run report, which is plaintiff 78, shows that the Sasol paramedics were first on the scene. Now that's small. He's under tremendous strain. He's severely injured. That's a small issue. Let's look at some larger ones. He testified that he never saw the 2020 rail operating manual. He testified that he never worked modules on it. He testified that he was never tested on it. Now, straight down the line, and here we go. He wasn't trained on it. He didn't do modules on it. Straight down the line, we know that's incorrect. We know from the Savage training records, and these are exhibits 127 and 85. These are Mr. Francis's records. And they show training on the rail operating manual as of September 29th, 2020. If you look at every page of this manual, it's a July 2020 manual. Now, either for some crazy reason, they decided to train him on an old manual 3 months later, or he actually was trained on this. And he acknowledged it. Most importantly of all, however, is what Mr. Francis testified to about phone calls. Remember, we have two phone calls. Phone call with his brother Kendrick and the phone call with his wife. Now at trial, he remembered a great deal about the phone call with Kendrick. Remembered if he asked him to be his best, asked him about if he was doing his job as his best man. He asked him if he'd gotten his shoes yet. Told him, if you don't get the shoes, I'm going to kick you out of the wedding. And he offers to get the shoes for him. But 3 months and 2 weeks earlier, when under the exact same oath, to tell the truth, Ms. Francis didn't remember anything about the call. Again, here's the testimony again. You had no recollection of the call with Kendrick. Now let's talk even more about the quest call with his wife. That's the more important. I'm going to give you his entire testimony from start to finish so that I'm fair here. Notice all the details he told you about this call with his wife in court in March 2026. He notices someone was on hold. He wonders who it was. He connected the call without realizing who it was. He realizes it's his wife. He screams for help. His wife asks him what's going on. He tells him, I'm dying. He tells his wife, I love her. He tells his wife to tell his kids he loves them. His wife tells him, God got us and you're going to be okay. And try to call for help. But again, 3 months ago, 3 months and 2 weeks before he sat on this stand, Mr. Francis was under the exact same oath, was asked the exact same questions about this call, and he remembered nothing. 2 months or 3 months ago, under the same oath, you didn't remember what you and your wife talked about, correct? Right. So, ladies and gentlemen, I'll put it to you that if you think you're dying under a rail car, and had a chance to have what you think might be the very last conversation you're ever going to have with your wife, the very last chance to say something to your kids, don't you think you would never forget the details of that call, whether you wanted to forget it or not. Even stranger is to suddenly forget the details of the call in December and suddenly remember them in March. This may be unpleasant to think about, but it's important to think about because it goes directly to this question. So let's go to the question. All right, it's the same question, except now it's for Francis and for Savage. All right. We already know the 4 things that caused this accident. Number 1, he chose to ride the train. That's 100% on him, and we know it was a cause of the accident because you can't fall off a train if you don't get on it. So this absolutely, yes, for Mr. Francis. We also know it was unreasonable and unnecessary to get on that train because he didn't ride the train on the first part of the job. So this was negligent conduct that caused the injury. Number 2, he didn't maintain 4 points of contact. That's what the rules require. The rail operating manual, the version we know he was trained on, the version we know he knew as of the time were the minimum safety rules that were imperative to follow, says always maintain 4 points of conduct. These are also, by the way, the rules he would have had to have mastered to pass the test for a yardmaster in 2021, which he testified that he did. So clearly he was aware of these rules, including, and I forgot to mention this on point number 1, he chose to ride the car. Riding rail equipment should be avoided wherever possible. It was absolutely possible to avoid this. He did in fact avoid it on the first part of the job. He didn't avoid it on the second. This, again, gives you a yes for Mr. Francis. Number 3, I think the evidence establishes that he was, in fact, on his cell phone at the time of the fall. And by the way, we're going to kind of skip through this for time. There was some discussion about his radio not working, and maybe that was an exception to why he had his cell phone on the job. You can recall, if you want to see it, on page 260 of his testimony, Mr. Francis acknowledged that his radio was working. Let's go to the next page. With respect to the radio, your radio was working that day. It was working. No exception to the cell phone policy applied. The cell phone records create the critical time zone. We know the fall had to happen between the end of Kendrick's call and when his wife ended her call after hearing him scream. During that window of about 12:15 to about 12:28, that's when the fall happened. That also means, as a quick aside, that all of this stuff about the technical data being exactly an hour off is another red herring, the technical data that Savage pulled. If you want to look at that, you'll see it is exactly to the second different from the times that are logged for the incident. If you don't, it doesn't matter because no one is alleging that the incident occurred at 1:15. It had to have occurred before the call ended between Mr. Francis and his wife. Quick aside number 3. The idea that nobody knew he was on the phone in 2021 is another red herring. Nobody knew because nobody had his cell records. Look at the date these cell records were obtained. Now, maybe Savage should have asked for them and they didn't. We don't know. What we do know is a fact you didn't know a year ago, but know now, doesn't become false just because you didn't know it a year ago. Now, if we learned the earth was round 200 years after we actually learned it, it doesn't make the earth less round. It's still a fact. It's still true. So another red herring, two more red herrings are Savage data times and no cell phone in 2021. Now, we don't need to know exactly minute by minute, second by second when he fell. Whether it's 12:15, 12:16, 12:18, 12:19, it doesn't matter. And remember the burden of proof here. Burden of proof is a preponderance of the evidence. What is more likely than not? That's what you're determining. Nothing more. So first, let's ask ourselves, is it more likely than not that all of this activity, this is something I made with Mr. Francis in his testimony, all of this activity that he admits he did occurred in an 8-minute window, meaning after he claims that he left the parking lot. Look at everything he had to do. Plus, that he told me there was a delay before he got his wife. Is it likely that all of this actually occurred after he finished the call with Kendrick and was working? Or is it more likely, given the time, that he was actually continuing to talk to Kendrick while he was doing some of this? What's more likely for you to decide? Second, let's think about this for a second, okay? Mr. Francis is on the phone, not just with anybody. He's on the phone with his wife for about 17 minutes before Kendrick calls. After about 17 minutes of talking to his wife, or 18 minutes, and after only 6 minutes on the phone with his wife, not just some stranger, he totally forgets that his wife is still on the phone. And at the same time, his wife totally forgets she's got an active call. She doesn't look at her phone for maybe 15 minutes. How often do we look at our phones? How often do we pick it up when we're just around the house? And how easy is it to see if you've got a call on hold? Is all of that more likely than not? Or is it more likely that what actually happened is something like this? That when that call with Kendrick ended, Mr. and Miss Francis went right back to talking. And they were talking on the phone right up until the moment that he fell. It wasn't on hold. They were actively talking. Could that explain why Mr. Francis 2 months ago denied any memory of anything that went on in that call? Because as you know, that was the first time that you'd ever been asked about it. Because at that moment, 4 years after the accident, he didn't realize anybody had his record or would ask him about it. And in that spur of the moment, he didn't have a story to explain why he was on the phone. Could that explain why he had no memory of the call in December? Could that also explain why, once he knew he was coming to trial, and he knew someone had his phone records, and he knew he needed to have a story to explain this, that all this detail suddenly emerged? What's more credible? What's more likely? Is it more likely he suddenly remembered in 3 months all of these details that he just had forgotten for 5 years? Or is it more likely that these details did not come from his memory? They came from somewhere else. If you decide the second version of the facts is more likely, then based on his cell phone use, you have to put a yes for Mr. Francis. And finally, he was riding inside the gauge. We've been over that many times. It's the only way. It's the only way he falls where he's injured. The physics won't allow it. Now, here's the important thing about the analysis on this question. Remember on question 2, you had to answer 4 consecutive yeses to get to a yes on Cecil. These are ors. Anyone will do. Anyone will do, and anyone will allow you to put a yes, in fact, mandate based on the evidence that you put a yes for Mr. Francis on question number 3. Now, what about Savage? This comes to really who you believe, what you believe. Cell phone never changes on Mr. Francis. Chose to ride the rail car never changes on Mr. Francis. That's all on him, no matter what. If you believe him, he wasn't properly trained on 4 points of contact, and that's up to you. Maybe that's a yes on Savage, but it's absolutely not a yes on Sassel. Maybe if you believe him, that the manuals were confusing. They're all Savage manuals. He just didn't understand that this controlled and the site-specific, the Savage site-specific did not. Maybe the manuals could have been written better. That could be a yes on Savage. If you think there should be a blanket rule prohibiting riding on rail cars, as plaintiff suggests, even though you can ride safely, we've already established that, and you must ride inside the plant and other places because of the distances and the speeds involved. If you think there should be a blanket rule, that goes on Savage. They made every single rule to do with the moving of rail cars. So if you believe any of that, you can put a yes on Savage as well. Let's look at the apportionment question real quickly. You're not going to get here, again, because you're not going to answer yes on number 2, because the evidence won't support a yes on number 2. But if you get here, keep in mind the ways in which this accident was caused. The causes of the accident: getting on the train, using his phone, not maintaining 4 points of contact, and being inside the gauge. The evidence is established those are the 4 causes of the accident. 3 of those 4 are squarely 100% on Mr. Francis. He got on the train, his choice. He was on his phone, his choice. He was inside the gauge, his choice. I'll submit to you based on that, the barest minimum number you can put on Mr. Francis is 3 out of 4, or 75%. And if you want to put anything else, 20 or 25% on Savage, there's not any evidence to put anything on Cecil. None at all. If somehow you saw something that I didn't see in the trial, the very most you could put on Cecil based on the evidence is 5%. Damages real quickly, and I'm almost done. I don't want to talk a lot about damages except to remind you what the standard is. They should be fair and reasonable. Ladies and gentlemen, no one is disputing that Mr. Francis suffered a horrible painful, traumatic, life-altering injury in this case? No one. The amount of damages to be offered, if you get to this question, is entirely up to you. But I'll just remind you, when you consider what is fair and reasonable, to keep in mind, he didn't have a brain injury. Thank goodness he didn't die. Thank goodness. Neither of those were possible, given what happened here. I'll also remind you that he only applied for one job in the last 5 years. And the one thing we know is if you don't apply for a job, you can't get a job. So on his loss of earning capacity, the one number you've been provided, I will remind you of the number that Dr. Piper provided you, which is the only number based on vocational testimony about what he can and can't do. That number is $268,837. If you get to this question and you start considering damages, keep that in mind. Ladies and gentlemen, this is my last time to speak to you. And hopefully it applies. That's the rule. Not my rule. It's not plaintiff's rule. It's the court's rule. After I'm done, Mr. Alford gets 30 more minutes to talk. That's the rule. When I sit down, no matter what he says, I can't say a thing. But please keep in mind a few things going forward as I close. Nothing Mr. Alford says is evidence. You heard the evidence from the stand and the documents that came in. Nothing he says in his final remarks can change the evidence. The evidence clearly is this was a horrible tragedy, a tragedy that no one wanted to happen, certainly not Sassol. Keep in mind, the whole motivation behind going to remote control locomotives was to get people off the trains as much as they could, to make sure this type of thing didn't happen again. You can't get them off all the time, but as much as you could. Despite that, it happened. We can't turn back the clock. We can't change the tragedy. But ladies and gentlemen, I'll leave you with one final thought, and that is, you don't change or fix a tragedy by committing an injustice. Blaming Sassol for what happened, Mr. Francis, on March 7th, 2021, even in part, even in small part, would be just that. A yes to question 1 or a yes to question 2 would be an injustice because the evidence doesn't support it and the law from the judge will not allow it. A yes to Sassol on question 1 or 2 wouldn't be right and it wouldn't be fair. The evidence conclusively established that Mr. Francis's mistakes caused this accident, Mr. Francis's choices caused this accident, and maybe Savage's mistakes caused this accident. I don't take any delight in telling you that, but that's what the evidence conclusively establishes. And the evidence conclusively shows Sassol did not cause this. Sassol is not responsible for this. Sassol should not be held accountable for other people's choices and other people's mistakes. And when you make your decision on the evidence, ignoring the red herrings, you will answer no to question number 1. If you get there, which you won't, you will answer no to question number 2. Or at the very, very, very barest minimum, you will put at least 75% responsibility, at least where it belongs, on Mr. Francis in question number 5. After you do that, answering no to 1, you'll go home. And you'll know at the end of the day, whether it was hard or easy, you did your job as a juror. You followed the evidence. You followed the law. And you returned to this court with a just and a true verdict. Thank you for your time.
Thank you, sir. Ladies and gentlemen, it was my hope that we would get through closing arguments before lunch, but your lunch has arrived. And I believe it is a warm lunch, so I don't want it to get cold. So we're gonna go ahead and take this lunch. We'll try to take a brief lunch today. I'm gonna try to get us back by about 1:30 if you all are finished eating. So that Mr. Elford will have his opportunity to have his rebuttal closing argument. I will remind you, you should not discuss this case amongst yourselves.
All rise for the jury.
Hour 7, but I didn't get us quite under lunch.
Yeah, that's all right.
Okay.
I didn't think you wanted to do your 30 minutes now anyway, because we probably need to reset.
Yeah, we
a little
did.
bit.
We did.
We will try to get back by about 1:30 so we can get this to the jury relatively soon.
Good.
You'll have a good lunch.
Thank you.
That's it. So I have the mock presentation of what I can say that I can give to you more helpful. That's okay. Yeah. Okay.
Appreciate it.
And you have my, I do, okay, I'll provide. Thank you.
You did that already? First one?
1:30.
You saw it? Yeah. The first one? Okay. Yeah, I'm loving the day we everything. Thank God it happens. Beginning of this year.
You ever forgot about your CPR?
Yeah, so there's a class this month.
The other girls went today, they went to farms, one of them this morning to CPR.
Oh, okay.
I don't know if it was at the academy, I don't know which one that is.
Is at the academy. Cause they usually have it at 701.
A little bit, right?
But, I haven't,
Why am I talking about trails through this? Any issues in the courtroom? Who's the group over here in the attorney ready room? Probably. What case is going to? I'm trying to see. But the threats have to do with this case, right? Threats? No. Okay. Yeah, protect your phones. It's 31. What's up, Keith? Pardon me. Oh, 13. Barbara.